No, family, I'm getting better, much better. And my apology for the delay. Advocate Chauke, you continue to be under oath.
I confirm, Chair.
Thank you, sir. Advocate Ngcukaitobi.
Thank you, Madam Chair.
Let's see how far we can go.
Yes, no, I think we will be quick this morning. I've taken up more than I deserve. Mr. Chauke, we had explored the Kekana situation, I think to the extent that we could in the last 2 days of your testimony. So I want to shift the focus to the matter of Lieutenant General Mdluli, which you've already testified about, and you've explained what your defense is, namely that there is a binding SCA judgment on the matter and that there's no basis to overturn that. But I just want you to look at the charge or the terms of reference again and then to close that issue. It's 3.1.2.
Yes, I'm there, Chair.
So the way is formulated says that the failure to continue with charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Tefo Abel Ramokhebe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramokhebe and related charges to be withdrawn, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, which decision caused a significant delay in proceeding with the charges concerned. So presumably when they say his involvement, they mean his alleged involvement, because his involvement was never actually established.
Indeed.
And then the next thing is this idea of causing the charge of murder to be withdrawn. What does that mean?
It means that when I've withdrawn the murder charge and refer it to the inquest.
Yes, all right. And then it says, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter. So I think that's where the mistake is against you. That's what you are being criticized for.
Yeah, there was a strong case in respect of the murder charge, which is wrong.
Precisely, but that's what they are saying.
Yes.
Yes. And then there's also, I think there's a second issue they're taking up with you, which is that your decision caused a significant delay in proceeding with the charges concerned. I presume that means, there was confusion in the evidence of Advocate Batoy about what this part refers to, whether it refers to the murder charge or it refers to the other charges, the 17 other charges. Like where was the delay?
Yes, I heard when she testified.
Yes. But we shall presume here that the alleged delay, the alleged delay cannot be on the murder charges because there can be no delay there. That was closed up.
Yes.
So it can only be the delay in the other charges.
Yes.
All right. But that's also fully dealt with in the SCA judgment.
Indeed.
Yes. So when they say charges concerned, they mean the 17 charges?
I presume so.
Yes. So therefore, the scope of the charge, it seems, would be you referred the murder to an inquest. That's number one, and they say that's wrong because there was good evidence, strong evidence. The second one is that you caused a delay in the 17 other charges. Would that be your understanding?
Yes.
All right. Now let's deal then with the first one. As I understand on Advocate Batoy's version, what she read here, according to her, was the opinion of Advocate Hali.
Yes.
And what Advocate Hali in turn read was a statement by is it Captain Rulof, sir?
Lieutenant Rulof, sir.
Lieutenant Rulof, sir, which was given in the bail application,
Yes.
and nothing in the actual investigation of the murder.
That's my understanding from reading that opinion.
Yes, yes. I mean, well, it's now common cause. I mean, that's why I'm happy to tell you, because it's established on the record that the one read an opinion, the opinion read another opinion. Yes. And by contrast, what did you actually read?
I read the statement in the case docket, as well as the prosecution memorandum and the representations that were made on behalf of General Mdluli.
Well, if you look back at the document we circulated at the commencement of your evidence, which is a list of annexures to the witness statement, which listed everything you read in Ketomano and everything you read in the Lieutenant General Mdluli case.
Yes.
Can you just take us to page 6?
I'm there, Chair.
And then take us through what you read in contrast to Advocate Harley, who read one document, and Advocate Batoi, who read the opinion that read one document.
Thank you, Chair. The first one is the affidavit of Michael Ramokhibe, which is on record VR 00553 to VR 000554. The statement, the second statement of Abel Ramokhibe, which is at VR 000028 to VR 000030. The affidavit of Lena Ntsekiseng Ramokhibe Mbuyisa, VR 000071 to VR 000073. A statement of Abel Ramokhibe prior to being shot is VR 000487 to VR 000488. Then the affidavit by Detective Sergeant Zelinda Samuel Domo, which is at VR 000546 to VR 000548. The affidavit by Ms. Malitsatsi Sophia Ramokhibe, that is the mother of Mr. Ramokhibe, VR 000042 to VR 000046. And the affidavit by Ms. Malitsatsi Sophia Ramokhibe, mother, which was written in Afrikaans, VR 00527 to VR 00529. A postmortem report at VR 000108 to VR 000111. A statement by Constellation CD Mudise, Butelezi, dated 2nd March 1999 at VR 000555 to VR 000557. Statement by Alice Manana, VR 000001 to VR 000010. Affidavit by Mohau Johannes Ramokhibe, VR 000047 to VR 000058. J88 Medical Legal Report, VR 000022 to VR 000027. Statement by Johannes Christian Duplessis, VR 000097 to VR 000104. Statement by Manyatela, VR 000193 to VR 000195. Affidavit by Lieutenant General Sitwanso Godfrey Libya, VR 000319 to VR 000321. A statement by Kimba, VR 000445 and 0 to 00171 to VR 00173. affidavit by Lieutenant Godfrey Chanto, Libya, VR 00322 to VR 000325. Statement by investigating officer Rulof opposing bail, VR 00748 to RM 0078 to RM 0084 and VR 000326 to VR 000430.
Yes, if you could just stop there. This is the statement that was read by Mr. Harley.
Yes,
The only statement he read from this document.
that's
And
how I
it's-
understand it.
It's not clear from his opinion whether he had access to the docket or not, but that's the statement he read. Now, what struck me was that this is a statement in the bail proceedings. It's not even a statement in the main case.
Yes,
And did Mr. Rulof give another statement in the main case?
yes,
He did.
he did.
Yes.
That is the one that is recorded as VR 000326 to VR 000430.
Yes. So he gave two statements.
Yes.
Yes, all right. All right. It's unclear then why.
And the one that, if I may,
Yes.
the one that Advocate Hali relied upon is which one of the two?
The one the RM 00748 to RM 00814. That's how I understand it.
Yes. We will just confirm that, Madam Chair. Now, I've asked Mr. Ramukhale to do that job. Then continue. This is now a second statement of, well, it's the third, if I'm not. No. It's actually a
It's one and
repetition.
the same thing.
Yeah.
I just made a mistake. I repeated.
Yes, it's the same thing. So we can scratch that one because it's referred to in the second column.
Yes.
All right. And then carry on.
A statement by supplementary by Mdluli, which is VR 000453. And then affidavit by Tembele Mtunzi, VR 000458 to VR 000473.
Advocate Ngcukaitobi, the statement of Lieutenant General Lebeya, the one that you have just read, is it the same statement as the previous one because the dates are different?
Madam Chair, I'm comparing it with the one at which is in the second column of the same page.
The same page 8.
Yes.
Oh, yes.
So it looks like he gave two statements, not three.
Thank you.
Yes.
So we must scratch the second one.
Yes.
Thank you, Prosecutor.
Yes, thank you.
And a statement by Area Commissioner Leonard Anthony van Tonder at VR 000579 to VR 000581.
Now, before you proceed, I just want to, because I just want to confirm something around the statement of Mr. Rulof, because it's the pivotal statement that became the Yes. Mr. Chauke, let's just get some detail out of this thing. Just to go back to the issue of Mr. Rulof, because I'm not sure if I understand precisely what's going on, and I just don't want to leave the panel as confused as I am. So the first document is the opinion from Mr. Harley and Ms. Wenzel, and that's dated, well, she's now Judge Wenzel, and that's dated LO 001047.
It's a LO.
So LO 001047.
10.
No, 1047, yes.
Volume 4 of the legal opinions.
Thank you, Madam Chair.
Yeah, thanks, yeah, I'm there.
So do you have this is the opinion of Mr. Harley and Ms. Wenzel, correct?
Yes.
Now, the reason I say that it's common cause that they relied on the affidavit, it is paragraph 5 of that opinion.
Yes, paragraph 5 reads, before delving into our process of reasoning and the evidence to support that reasoning, there are primary facts and observations.
Preliminary facts.
Preliminary facts and observations we should set out to better understand what is to follow. These are all derived from the affidavit of Colonel Cobus Rulof, who had investigated the charges against Lieutenant General Mluli. We attach a copy marked A.
Yes, now the problem is that when the NPA gave us this, they didn't give us Annexure A itself, what it says. But anyway, the fact that that's the only thing they read is clear from that report, from that opinion, because they never explain what is the other source of their information.
Yes.
But it's clear that they relied only on Mr. Rolof's affidavit.
Yes.
Now, that we have to find it somewhere else, the affidavit. We find the affidavit at in another section. Yes, in the Mdluli docket, what we find in RM 00010, which is under RM1.
It's a page.
So the document I have here is RM 00010. Got that.
00010.
Yes.
Yes, on there, Chair.
Yes. Now, if you look at that, that is an answering affidavit by Cobus Dimeya Rolofse.
Yes.
Yes. And the reason he submits that is to oppose a bail application by Mr. Mdluli, correct?
Yes.
Yes. So that's one candidate about what that Annexure A is about. And the grounds for opposing the bail would be at RM 00029.
I'm there.
Yes. And that's where he talks about the strength of the case at RM 00030. That in his opinion, the case is very strong. Can you see that?
Yes, I see that.
Yes. So that's one potential candidate about what Annexa A is, but we still don't know. And then there is another document also signed by Mr. Kobus Dimeya Rulof, which is under RM 00748. RM3.
It's 4.
So that's his
007.
48.
Yeah, yes.
Now, that is another statement. I'm not sure if it's an affidavit or a statement. But what caught my attention is that in paragraph 3 thereof, he says he has deposed to 2 affidavits dated 11 April 2011 and 12 April 2011. Can you see that?
Yes.
And the one we just looked at, it seems to be the one of the 11th of April and not the one of the 12th of April. So the one we looked at RM 00010.
It's 11 April. The one that we looked at was
Yeah, so that's
11
the
April.
11th of April if you look
Yes.
at
Yes.
RM 00047.
Yes.
Yes. And then the 12th of April, I'm not sure where that is. And so when you look at Annex A, it is utterly confusing about which of those 3 affidavits Mr. Hale read.
Yes.
Yes. Now, this is where the problem then becomes, is that when you see Advocate Batoyi, who is the person that must make a rational decision to charge you, saying, I've relied on Mr. Hale's affidavit. And then, on Mr. Hale's opinion, when you look at the opinion, it talks about Annex A, it doesn't attach Annex A. You try and find out from the record, you find 3 different documents, and you can't work out what are they talking about.
I agree.
Yes. Regrettably, Advocate Batoyi left this chamber before we could cross-examine her on this point.
Yes.
Yes. All right. I needed to clarify that when we are talking about Mr. Rulof, that we are actually talking 3 different statements, and we can't work out which statement was read and relied upon by, well, we know for sure that there is no statement read by Advocate Batoyi, but we can't work out which statement was read by Mr. Hale.
Yes.
Yes. Unfortunately, she can't testify. He's an advocate. He can't testify here, so we would just never know.
Yeah, we can just assume which one statement and take it from there.
Well, we can't make assumptions. Yeah. This is your career at stake. There has to be proof. Now, you've dealt with the supplementary affidavit of Mr. Mdluli.
Yes.
And there is also Mtunzi Omche and Tembeni Mtuzi.
No. Omche.
Okay, carry on.
The other statement is a statement of Major General Harold Godfrey Engelbrecht in VR 000608, VR 000614. And the state.
In relation to, sorry, Council, in relation to the statement of Mr. Mdluli's written statement by supplementary, does it mean that this statement was supplementing a previous statement by Mr. Mdluli?
Yes, when he was at the bail hearing.
Where is that statement in the list? Because I see it's a supplementary statement. The one on page 8.
Yeah, the statement, I'm not so sure on record what is it, but it's marked A53 in the case docket. And here I see it's V000453, VR.
And this one is a supplementary affidavit statement?
Yes.
And the initial one, what is it marked in the record? We can search later.
I'll try and search, but the supplementary affidavit is the one that was written by hand. It's not typed.
I think the question by the chair is, in the docket, where is the first statement that is being supplemented? I think that's really the question. So
yes,
we must just try and find that.
I'll find out. It was supplementing the affidavit that he made in the bail application.
Oh, I see.
I'll
if
trace
we find that affidavit,
yes.
Okay, we've got that.
It does not appear in the list. Where is it appearing in this list?
I omitted to list it on the list, Madam Chair. My apologies.
Yeah, we understand. We'll get the reference number of that statement.
Yes.
Perhaps Mr. Ramokhali can locate
Yes, I have no doubt.
the place in the record where we can find the main statement.
Yes. Thank you, Madam Chair. We shall make sure. Mr. Chauke, you are saying that was a handwritten supplementary to the application in the bail proceedings?
Yes.
All right. Well, that should be easy to locate. All right. Carry on then. Following page, page 9.
A statement by Deputy Provincial Commissioner Benning Tanderson Tlemeza at VR 000831 to VR 000846. And statement by Lieutenant Colonel Peter Jansen Viljoen at VR 00932 to VR 000934. And representations by Mdluli at RM 00338 to RM 00355. The prosecution memorandum regarding representations by Advocate Van Sale and the two others, Galega and Advocate Barnard, the RM 00881. I just did not take the last page there. I omitted to record how many pages are there. Inquest report, which is at RM 00889. and the inquest findings by magistrate at RM 01002 to RM 01044.
Yes. Now, what seems to have become, look, there's quite a lot of documents in this docket.
Yes.
Quite a lot of things that you read, and you came to your conclusions. Now, what it seems, and I'm speculating here because we were denied a chance to cross-examine the complainant by her walkout, is that if you look at the item referenced as prosecution memorandum, we can go through that. It's RM 00881. Maybe let's just do that rather than it's RM 00881. It's the thing that I'm saying. Let us know when you have it.
00881.
Yes. It would be under RM4.
Yeah. It ends at RM 00884.
Yes, all right. No, that's fine. But I'm interested in where it starts, RM 00881.
Yes, I'm there.
Yes. Now, there were many occasions when Advocate Batoy said, well, the prosecutor said that there's a good case on murder. You remember that?
Yes.
Now, the only time I can find in this record is that reference is this document, this 4-page document, RM 00881. And that is a response to the representations that were made by Lieutenant General Mdluli.
Yes.
He raised a lot of things about the conspiracy against him, etc.
Yes.
But the analysis around the strength of the case of the state, you'll find that at RM 00883 under issue 2.
Yes.
Yes. Now, item 1, they say the case on the murder charge relies solely on circumstantial evidence. Those include a threat by the accused to the deceased family that the deceased will be killed. 2, the state has direct evidence linking the accused to kidnapping, assault with intent to do grievous bodily harm and intimidation. And 3, all this evidence is of incidents that took place prior to the murder of the deceased and are in relation to the love triangle involving the deceased and General Mdluli. We have consulted with all of these witnesses extensively and hold the view that their evidence constitutes prima facie proof of these crimes. Paragraph 4, the attempted murder charge, count 13 and 14, are also based on circumstantial evidence. 5, the overall picture painted by this evidence is that of a thwarted lover who was hounding the new love of his girlfriend and who would stop at nothing to get rid of his fellow suitor. And 6, the charge of defeating or obstructing the course of justice encompasses the whole history of the further confirmed by the fact that two dockets implicating him in this matter were discovered in his safe.
Yes.
Now, there is nothing else that I could say from this memorandum that analyzes the underlying evidence in detail. I looked at the prosecution memorandum that people like Advocate Mayema did for for Cato Minor, and I saw the detail at which they were going through, analyzing each witness, the weaknesses on each witness, the strengths on each witness, the likely questions from the bench, the likely attacks from the other side, and it went on to more than 100 pages. But here I found only 6 paragraphs, and no more than that. Did you find anything else other than these cryptic paragraphs?
You mean from the
Yes.
prosecution memorandum?
Yes.
No, that's what was there in the prosecution memorandum.
Yes.
I had to interface with that against the evidence, which
I understand. I'll deal with that. But I just want to know if there was anything else that emanated from them other than these 6 cryptic paragraphs.
No.
Yes. Now, when Advocate Batoyi repeatedly talks about the prosecution memorandum that outlined that there was a strong case, she never actually went through the prosecution memorandum herself on her own version.
Yes.
She just heard from someone that there was a prosecution memorandum. And she never took the panel to the contents of the prosecution memorandum.
Yes.
Yes. Now, and when you look at the prosecution memorandum, it actually doesn't analyze the evidence. At least the only comparative analysis we have here is the Mayema dossier.
Yes.
That actually shows you how this is done. Now, so then you have these 6 cryptic paragraphs that basically say, look, we admit that the case is circumstantial, but we think it's strong.
Yes.
Yes. What then did you do after you received this?
But only in relation to the murder
To the murder, yes.
and attempted murder.
Yes, yes. Murder and attempted murder, yes. But the other, they say it's direct. Yes, that's correct, Madam Chair.
After that, Chair, I called for the case docket
Yes.
to be placed before me so that I can read the case docket as against their submission and the representations which came from General Mdluli.
And why do you call for the case docket? You see, because we've got a strange thing here where the NDPP takes a decision of monumental proportions. She's never read a single docket.
No, I needed to apprise myself so that a decision that I will make one way or another should be based on the facts and based on law.
Yes, yes. But I mean, did you feel that you couldn't make a decision as a decision maker without having read the underlying documents?
Indeed.
Yes. And then what happens thereafter?
No, I got the case docket. I went through all the statements and discovered that even on the summary of the prosecution memorandum, there is an omission in respect of the evidence relating to the death of Ramkhebe, which they did not analyze it.
And what was that omission?
That after, when there was this assault and kidnappings and the like, there was a friendship that developed between Ramkhebe and Kimba and Mthunzi. And even where Ramkhebe borrowed the car from Kimba to go to Nelspruit and came back. And then even on the attempt that happened to him, firstly was he was driving that car of Kimba.
Yes.
And the notion that he was now always fighting, having problems with Kimba and Mdluli and them, to me that indicated that there's something more to that, and I understood why. Maybe the prosecutors would have omitted that, because that negates the theory that a jilted lover was now busy pursuing him, because these guys were also were working with Mdluli at the police station at Fort Solaras. And even that attempted murder, it was reported to them, and this Dlomo was the investigating officer, and Mthunzi was also the one who took Abu Ramkhebe to the police station to open the case of attempted murder.
Yes.
Yes.
And those omissions, why were they important for you?
The theory that we had developed to say he was killed by Mdluli because of his the love affair, that he was angry about it, and it's negated by the fact that there was now a relationship that developed between him and Mdluli's associates.
I see.
Yes.
After the...
Yes. After the kidnappings, and it was almost about 2 or 3 months thereafter.
Yes.
Yes.
Now, you had, I suppose, how many choices did you have? 2 or 3 choices. You could simply go ahead with the prosecutors.
Yes.
Or you could overturn them.
Yes.
And if you overturn them, you could have just withdrawn the charges, full stop.
Yeah, I couldn't withdraw the charges. The other charges, there was strong direct evidence linking all the 3 of them to the commission of the offences. I could have just said withdraw the murder charge and proceed with the other charges, but that was not going to be practical in the sense of the theory that was created by the investigation team, which was given to the prosecution team. Yes. So I had to test that theory through the inquest, where the evidence would have been tested, and that's exactly what happened.
Yes. Yes, that's the point, that you could have withdrawn it.
Yes.
But your view was that an inquest would be better.
Yes.
And why?
To ventilate and investigate the theory, whether the theory that the investigating team is having and the prosecution team is supported by the evidence, because on the evidence that was my problem, that there was no link. The theory is a theory. It does not suggest that factually you will be in a position to prove that. And then even if you apply inferential reasoning, whether that will be the only inference that you can draw, that this Ramokhiba was killed only because of the love affair that he had with Mdluli's girlfriend.
Yes. What would be the benefit of an inquest?
The benefit of inquest, that theory was going to be determined, and witnesses were going to testify and will be subjected to questions from the magistrate and from the prosecution team and Mdluli's attorneys.
And what if the prosecutors say, let's go to trial instead of an inquest? How do you explain that to them?
No, exactly what I did. This is the decisions that I have made. That you are recommending this. My view is this is what should happen. Ultimately, the decision to prosecute is the decision that must be made by the DPP, who was made at stage.
Yes, now I understand. But and what were the interactions, if any, between you and the prosecutors, Mr. Van Zyl and Mr. Barnard and Ms. Tembeka?
No, we discussed. I showed them my reasoning, and they accepted my reasoning, and that's why I issued the instruction and then issued the request to the magistrate to do a formal inquest, and I listed these witnesses who were supposed to be examined at the inquest.
Yes. Because you see, we have this thing about the Ketomano where the NDPP just makes a decision, announces it publicly, has never engaged the prosecutors.
Yes.
And in your case, what did you do?
I engaged the prosecutors, like I indicated. Yes. And it's even them who were leading the evidence at the inquest.
Yes. So, but before the inquest, you spoke to them and you explained what approach you were following and why?
Yes.
Yes. And then what did they say to you?
No, they said they accept my decision, and then they will consider a matter after the inquest.
Yes. I see. And
then, so I had to instruct them to withdraw all the charges, because proceeding with the other charges in the circumstances that an inquest was going to be held, it will just create fragmentation of trials in case the inquest would elucidate further evidence or facts that would convince me that indeed Mdluli needs to face a charge of murder.
Look, I mean, the strange thing is that we went through this last week. The SCA says that's fine because it's not a problem to avoid fragmentation of trials.
Indeed.
And this is what they're charging you with now here, that you should have proceeded with the other charges.
No, I take it and accept that that comes because of the misreading or not understanding the SA judgment.
Yes, I understand. All right. So we are now at the stage where you've spoken to the, firstly, you've analyzed the docket, you've looked at the memorandum, you've identified weaknesses in the memorandum and in the evidence, and there are gaps, and you say, okay, to satisfy myself, let me rather follow a cautious route of an inquest.
Yes.
If the inquest finds that a case of murder is sufficiently established, what were you going to do?
I was going just to proceed to say, proceed and charge him with all this, the murder charge and the attempted murder charges.
You see, what I need to put to you is, you know, there was another theory that the NPA appears to have been working on, and that is the theory contained in the opinion by Mr. Harley. Let me just take you through that. And they seem to have thought that you had some kind of a double agenda, you know. So if you go back to that opinion of Mr. Harley,
If you can help me with the page.
LO4. So I want to look specifically at LO 001056.
056.
Yes.
So 05.
Sorry, 001056.
That will be 1056.
Yes.
Yes, I'm there, Chair.
Now, this seems to me to be the whole problem with this, is that ordinarily you have a prosecutor who's the DPP, he looks at the work of other prosecutors who report to him, and then he says, look, your work has got discrepancies, I need it to be checked by a magistrate. And everyone is happy with that.
Yes,
And that's in the normal course of doing your work.
indeed.
Until somebody then introduces this theory, and I'm going to show you what actually seems to have been the problem. In paragraph 13, this is what Mr. Harley writes. Lieutenant General Mdluli was obviously anxious not to be prosecuted on either set of charges. To avoid prosecution, he had to make representations to two different persons, the Special Director of the Special Commercial Crimes Unit. Now, you were not involved in that one. That was
No.
Mr. Matenjo.
No, it was Mr. Mkhwebe.
Sorry, Mr. Lawrence Mkhwebe.
Yes.
Now, and then he says, in respect of the fraud charges and the Director of Public Prosecutions in relation to the Ramokhebe matter, correct?
Yes.
And then he says, by March 2012, he had succeeded in doing so. The question is how. It is in this context that Advocate Chauke's decision should be considered. Paragraph 14, the chronology of the events and the context in which Advocate Chauke made the decision to withdraw the charges demonstrates that in all probability he did not act without fear, favor, or prejudice in making the impugned decision. We summarize this case below. I mean, how do you respond to that?
That's a lot of nonsense.
No, well, let's not be rude. But how do you respond to that, that he is accusing you of not acting with fear, favor, or prejudice?
No, it's very unfair to me.
Yes, but it's false.
It's false.
Yes. Now, paragraph 15, on 7 July 2009, Lieutenant General Mdluli was appointed as the Divisional Commissioner of Crime Intelligence. His appointment was not made directly by the former President, Mr. Zuma, but it was made under highly suspicious circumstances which need not be explored here. Now, you know, personally, as an advocate, cannot understand how you can make a statement like this without any underlying facts, because the opinion doesn't contain any facts that Mr. Mdluli's appointment was questionable.
But from what I understand is the theory that was developed because Mdluli said he was being prosecuted because they didn't want him to be appointed as the head of crime intelligence.
I understand that Mr. Mdluli can say anything. He's a witness. It's like Major General Boyson. I don't care.
Yeah.
What I care about is an opinion that is relied upon by the NDPP to prosecute you. And that's why I want your comment on paragraph 15.
It's just unfortunate that the opinion came with this theory, which is untenable.
But I mean, are there any facts here that support what is being stated?
No.
Yes. Now, then paragraph 16, Lieutenant General Mdluli and Advocate Nomgcobo Jiba, the former acting NDPP, enjoyed a special relationship with and the protection of President Zuma, and both appeared to have a direct line of communication to the president. Now, again, are there any facts here that now Ms. Jiba and Mr. Mdluli have a close relationship to the president?
Not that I'm aware of. Advocate Hali would have.
No, in their opinion.
No.
Yes. But what is the basis then for this?
There is no basis at all.
Yes. Now, then, Advocate Jiba repeatedly told officials within the NPA and spoke openly within the NPA corridors that she had the ear of the president. Lieutenant General Mdluli lodged complaints with former president, and it seems that his complaints were taken seriously. We explored that below. Again, is there any basis, factual basis set out here for this?
No.
Yes. And then, paragraph 17, on 8 September 2010, President Zuma granted Advocate Jiba's husband, Mr. Buka Nancy, a presidential pardon despite warnings from the Minister of Justice, Mr. Jeff Radebe, that Mr. Nancy had not met the most basic requirements for such pardon. This evidence is documented in an affidavit of Advocate Karen van Rensburg that was filed with the State Capture Commission and appears on its website. This case is amply supported by the documentation attached to her affidavit.
No, there you have it.
What do I have?
That the theory came from Karen van Rensburg.
Yes.
Yes.
Advocate Karen van Rensburg.
Advocate Karen van Rensburg.
Yes. But it's not tested anyway. There's no trial. There's no cross-examination. Nothing. It's just people's own thumb-sucking.
Yes.
Yes. Then, a day later, a person bearing the name of Nomgcobo Jiba, and this is really, you have got to look at this. It's truly astonishing what is said here. A day later, on 9 September 2010, a person bearing the name of Nomgcobo Jiba, who apparently had a different identification number, and Lieutenant General Mdluli traveled together on a flight to Durban. Advocate Jiba was confronted with this evidence in the Mokgoro Commission of Inquiry. She denied that the person in question was her. Given the surrounding circumstances, it seems with respect far too coincidental that it was not her. Now, what do you make of this?
It's very unfortunate.
Is it, but in terms of the evidentiary quality that you would expect from a senior counsel advising the NPA, that you just rely on your own speculation.
That's why I'm saying that he looked at the gossip and the innuendos from people in the NPA, like Advocate Karen van Rensburg. You would remember Advocate Karen van Rensburg is the one who filed the affidavit in the way the NPA was alleging that it was not represented in this inquiry, when the contrary is correct. So I'm not surprised at all.
Yes. Then, on 11 November 2010, Lieutenant General Mdluli addressed
Sorry,
it.
before you continue, all these allegations that are being mentioned, especially at paragraph 17 and 18, went to the State Capture Commission.
Yes.
Do we know whether there was any pronouncement on any of this, or what was the outcome? I'm looking at paragraph 17 where it is said that Mr. Nancy, whom we know that it's Advocate Jiba's husband, was granted pardon despite warnings and that he had not met the most basic requirements for such pardon. Did the State Capture Commission make a pronouncement on this, or was there an effort to review this decision? Because if it was taken arbitrarily, it is an administrative decision that can be reviewed. Was there any pronouncement, or was it reviewed? And maybe let me just lump it with what is contained in paragraph 18, where Advocate Jiba says, the person that you're talking about is not me. Was there anything further done to try and prove that it was Advocate Jiba for us to be dealing with it now, entertaining it now here?
Chair, not that I'm aware of. As indicated when Advocate Shamila Batoy testified here, she said regrettably the Zondo Commission did not make any findings. Now, what has happened here, because I also filed an affidavit at the Zondo Commission, when it was supposed to be our turn to respond to the allegations from Karen van Rensbeck et al. The Zondo Commission said this was not within their terms of reference, and then they will refer them back to the NPA to be dealt. That's why when she was Advocate Shamila Bato, when she was here, she said, regrettably, Zondo Commission did not make any findings.
So the NPA did not do anything after being told by the State Capture Commission that this is outside their terms of reference?
Not that I'm aware of. What had happened thereafter is this process that we are in now.
So we can simply disregard this because it does not take us anywhere. I mean, we do not have to advocate. Jiba is not before us. It's only her decision in relation to the Katomena that is before us. But other than that, the rest of this are not relevant to our terms of reference, unless if they show something that I'm unable to grasp.
Chair, they just saw the appetite that Advocate Karen van Rensbeck, Advocate Batohi, some civil society groupings they had at Jiba. This is what I can sum it that way. This appetite about her and what have you, I don't know.
Thank you.
May Council, the issues referred to at RM 00883, that the cryptic issues, you remember? The 6 paragraphs that Advocate Ngcukaitobi referred to earlier.
883?
883, RM 00883 is volume 4 of Mdluli. It's a prosecution memorandum. In which representations by Advocate Mdluli, yes, Advocate General Mdluli, yes. The first issue regarding the murder charge and the attempted murder charges, they say, was based on circumstantial evidence.
Yes.
It is for that reason that you referred the matter for inquest.
Yes.
Can you just elaborate for those who do not understand what circumstantial evidence is?
Yes, Chair. Circumstantial evidence shows that you don't have direct evidence to link the accused with a particular offense. You rely on circumstances and inferential reasoning to conclude that this might be the person who is responsible. Now, in that kind of reasoning, when you reason, you must exclude other possibilities in respect of that circumstantial or inferential reasoning. At the end of the day, circumstantial evidence, at times you will have some facts outside of that which might corroborate that circumstantial evidence. And in this instance, my reasoning was that there are no other facts other than that there is this love triangle, which is supposedly the main cause for his death. And once one reason with those kind of circumstantial evidence, you must draw the conclusion that one inference which points to that. And in my thought and in my reasoning, that was not the only conclusion that one could reach based on the facts as I had them at the time.
Will I be correct, given in your experience as a prosecutor, a very experienced prosecutor, that when you are faced with circumstantial evidence and you have to make a decision whether to prosecute or not, or to go to trial, proceed to trial or not, you often encounter challenges in formulating a conclusive view that there is indeed a prima facie case.
Indeed, Chair.
Am I correct?
You are correct, Chair.
Now, with this background, looking at the opinion of Advocate Halley, where they tabulate all these things that they are mentioning, which seems to me to constitute gossip.
Indeed, at the highest level.
Is there any way in this opinion, I might have misread the opinion, wherein the writers of this opinion deal with those aspects of the circumstantial evidence?
Not that I'm aware. Not that I'm aware, Chair. I tried to also go through it from time to time when I knew that I was going to come here, and I couldn't really see where they actually discussed the actual effects and the actual evidence.
In the absence of any analysis of the circumstantial evidence that you were confronted with, that might have assisted in coming to a reasonable conclusion whether you were wrong or not. What do we then make of this opinion? From those paragraphs where reference is made to you having acted, that you did not act without fear, favor, or prejudice, that you relied on those things that have been mentioned in those paragraphs, without the analysis that I'm mentioning, what should we then make of these paragraphs?
I respectfully submit that they must be ignored and not be taken into account, because it's untenable and not based on evidence, what is contained on those paragraphs.
Now, the suggestion at paragraph 14 of the opinion that in all probability you did not act without fear, favor, or prejudice, you know that is a serious allegation.
I know, Chair. And
it is serious because of your constitutional and legal obligation as a prosecutor, correct?
Correct, Chair.
Now, the averments that you did not act without fear, is it based on those paragraphs? For instance, paragraph 15 and 16 regarding the the mentioning of the appointment of Mr. Mdluli by President Zuma, and that General Mdluli had a relationship, a special relationship with Advocate Jiba, that Advocate Jiba's partner was given presidential pardon. I'm just mentioning in summary those aspects. And I'm just trying to determine what relevance are these aspects to the allegation that you were fearful.
To the contrary, I was not fearful for that simple reason that if I was acting with prejudice and the like, and I was to confirm to this theory, then it means I would simply have withdrawn the charges against Mdluli in their entirety. But because I was acting without fear or favor or prejudice, I had to look at the facts and satisfy myself that there is justification for the charges, one way or another. In summary, I acted without fear or favor or prejudice. Because this reasoning, which is here in this paragraph, is prejudicial in themselves.
And it's not consistent with your decision referring the matter for inquest.
Indeed, Chair.
Yes, thank you.
Thank you. Mr. Chauke, let us not poison this forum further by emphasis on the gossip.
Thank you, Chair.
I just want to answer something directly on this line that the Chair was engaging you with, which is, you know, if it was true what Advocate Harley has written there, all of that gossip, what did you actually do? Now you've got the results of the inquest. They say that on murder, it's no good. But what did you do, as a matter of fact?
I did nothing wrong, Chair. Because immediately after the findings of the inquest, I called in the prosecution team to say, here we are. You guys must now amend your indictment and proceed with all these other charges.
Yes.
Then the team leader, Advocate Faizan, he says, no, I heard that your decision to refer the matter for the inquest is being reviewed by the High Court in Pretoria, and in that sense, we cannot proceed with the matter on trial given under the circumstances, which I agreed with him because it made sense that one will have to wait for the judgment from the High Court, which was delivered by Murphy J. Yes. And then after the judgment was delivered against the NPA and DPP, that decision was appealed to the SCA. And the SCA came out with the judgment that determined that my reasoning and the process that I followed was rational.
Yes. But also they affirmed you on the fragmentation issue.
Yes.
Insofar as they're talking here about the delay in the other charges.
Yes.
Yes. But the point I'm saying is, what did you actually do against Lieutenant General Mdluli? You remember that this is the person via gossip that they are associating you with. And Advocate Jiba and President Zuma, the whole conspiracy that they have cooked up at this Advocate Van Rensburg's affidavit. But you have a choice to say, am I charging this person? Because if you're part of this large conspiracy, what did you actually do?
No, I charged Mdluli in respect of all the other offenses of kidnapping, assault, and on the victims. If I really had anything to do with him that I was protecting him, or probably I would have found a reason not to proceed with those charges, given that there were even more than 11 years, which is irrelevant. The fact of the matter is I was faced with a decision to make there, and I made it accordingly without any fear or favor or prejudice.
But as I understand, you are, in fact, the only person who's ever charged Lieutenant General Mdluli.
Yes.
And then what happened after that? Once you charged him, he went to a trial?
We went to a trial and they were convicted and they were sentenced to 5 years imprisonment.
Yes.
Yes.
Which has never happened before.
Yes.
And then the only person who ever charged Lieutenant General Mdluli is now being accused here, strangely, of trying to protect him. But you send the man to jail for 5 years.
Yes.
Yes.
During the testimony of Advocate Batoi on this aspect, when we asked her as to what the problem is in relation to you having withdrawn the murder charges, my recollection, subject to correction, was that she said you did not reinstate the charges.
Yes.
If my understanding is correct, she meant, unfortunately, she left before we could canvass those issues with her. My understanding of her testimony was that your failure to reinstate those charges after the decision of the Supreme Court of Appeal is what really gave the problem and led to her doing what she did. Because she seemed to have understood that withdrawal per se does not put an end to a case, a criminal case. It can, at a later stage, be reinstituted. Is my recollection of events correct?
They are correct, Chair. What has happened, as I indicated, there is a misreading or misunderstanding of the judgment. Once the SA made the judgment, it took the decision to decide on the murder and the murder and charge back to took it to the national director. I couldn't, in terms of that judgment, make a decision myself, because that decision became now the decision of the NDPP to make, which he made. So how Advocate Batoi and those around there could consider, even the opinion concluded that I failed to reinstate the charges once they were withdrawn, it's beyond comprehension.
If we can just, maybe if you remember where we find Brand J's order. Brand JA's order, rather.
It is CL. Where is CL? CL00371. That's CL2.
00371.
71.
Thank you, Counsel.
I'm there, Chair. I got it.
Paragraph 54, the order of the Supreme Court of Appeal. Would you just quickly read the order?
Thank you, Chair. In the premises, it is ordered that, 1, the appeal succeeds only to the extent that paragraphs B, E, and F of the order of the court are set aside. 2, the orders in paragraphs A, C, D, G, and H of the order by the court are confirmed, but renumbered in accordance with the changes necessitated by the setting aside of the orders in paragraph 1. 3, it is recorded that the following undertaking has been furnished on behalf of the first appellant. A, to decide which of the criminal charges of murder and related charges that were withdrawn on 2nd February 2012 are to be reinstituted, and to make his decision known to the respondent within 2 months of this order. B, to provide reasons to the respondent within the same period as to why he decided not to reinstitute some or if any of those charges. 4, there shall be no order as to costs in respect of the appeal.
As regards Order 3A, as you mentioned, the matter was now in the hands of the NDPP.
Yes,
This time it was Advocate Nkasana, correct?
it was Mr. Ngasana.
The matter was now out of your hands.
Yes.
Thank you, Counsel.
Thank you, Madam Chair. Can you go to your bundle where there's your statement together with its attachment, and go to page 6A 161?
Maybe before we go through that bundle, I should ask questions. I thought you're still going to be working on this portion, but then, yeah. Advocate Chauke, you say that your decision was different from that, or your view was actually different from that of the prosecution team that was looking at the Mdluli matter, the matter in particular.
Yes.
Am I correct? And you engaged the prosecution team about what is concerning to you, and nevertheless, as a cautionary measure, you took this matter, you referred it for inquest.
Yes.
And you say that the members of the prosecution team, the very prosecution team that had decided that the matter should be proceeded with on prosecution, are the ones that led evidence, witnesses' evidence at inquest.
Yes.
At the inquest, yes.
Yes.
And once the inquest was concluded, the magistrate gave its ruling, its decision.
Yes.
Now, do you know as to, upon receipt of the decision of the magistrate, what was the view of the members of the prosecution team, the very ones that were actually active at the inquest? Were they satisfied, according to your observation or even what they said, about the decision of the magistrate, or was there any issues from them?
According to me, they were satisfied. They understood the reasoning of the magistrate, and I did not take it any further from there.
Okay, yes. So they too now were satisfied with your thinking and agreed, based on the reasoning of the magistrate, that you were actually correct.
Yes.
Now, after the receipt of the inquest outcome, you then directed the prosecution team, Fanzale and them, to then proceed with the other matters.
Yes.
And how can we describe this? Can we say that you gave a directive that the other matters be proceeded with without delay, or did you delay in some way or the other?
I did not delay it at all. I think it was 2 or 3 days thereafter, once I received the record of the findings from the magistrate, and having studied that, I called the prosecution team, and I explained to say, given what has happened and the reasoning of the magistrate, I'm satisfied that the decision that I've made is correct. You can proceed with the other charges.
So this actually suggests that the question whether to proceed with these other matters depended on what the outcome would be, but in respect of those matters, you were resolute on proceeding with the prosecution. The
Ye-
only thing that you were trying to avoid was staggering the matters. Is that a correct conclusion?
That is correct, Chair.
And would you say that the NDPP or the NPA actually ought to have become aware of the fact? Let me rephrase it. I don't think I'm asking the right. Now, but for the advice from the prosecution team that the decision of the magistrate was, the judgment of the magistrate was under review, these other matters would then have been proceeded with.
Yes.
Now, reference to, I see Advocate Hali's opinion has spent a lot of time dealing with issues that concern Advocate Jiba. And I look at that memorandum, that opinion. It was written in 2023. Is it correct that that was long after Advocate Jiba had left the NPA?
Yes.
Thank you.
And then Mdluli and the others were by then, I think they were in prison, serving the five years.
Right.
Yes.
Thank you. That's a bonus answer. Thank you.
In relation to which charges?
In relation to kidnapping, assault, and defeating the end of justice charges.
Yes.
And you may?
No, I'm happy to yield.
Yes,
Madam
thank you.
Chair.
And I thought that the point that I asked you about Order 3A of the Supreme Court of Appeal, just to take it to its logical conclusion, the charges were subsequently reinstated.
Yes.
That is the murder charge.
No.
What happened to those charges?
Mr. Ngasana made the decision that there is no enough evidence to proceed on the murder and attempted murder charge, and he informed the freedom under law accordingly through Cliff Decker attorneys.
What decision then did he make? Not a prosecute?
He made a nolle prosequi in respect of murder and attempted murder charges, and indicated that the trial is going to proceed in respect of the other charges as directed by me.
Yes. Was there any challenge to that decision by anybody?
Not that I'm aware of. Chair.
Thank you.
Thank you, Madam Chair. I think we were actually on the same point. I was going to ask the witness to look at 6A/161 of the attachments to your statement.
Yes, I'm there, Chair.
Yes. What is that document?
It's a letter written by Mr. Ngasana, the National Director of Public Prosecutions, to Tricia Erasmus, Senior Associate, Cliff Decker, Hofmeyer Incorporated, dated the 17th of June, 2014.
And then can you just read the contents of that document?
Dear Tricia, the above matter in your letter, facts dated 5 June 2014 refer. Kindly be advised that after careful consideration of the evidence contained in the dockets as well as the transcription of the inquest record, the state has taken a decision to reinstate the following charges against Mr. Richard Nagi Mdluli. 1. 5 counts of contravention section 1, subsection 1B of the Intimidation Act 72 of 1982. 2. 2 counts of kidnapping. 3. 2 counts of assault with intent to do grievous bodily harm. 4. 2 counts of assault common. 5. 1 count of defeating and or obstructing the end of justice. Due to the high-profile nature of the matter, the state is considering arraigning the accused in the High Court. Please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage due to the lack of evidence implicating him thereto.
If you can just
Please.
stop there, no, just stop there, because he's then talking about fraud and corruption, which was Mr. Mkhwebe's department. Your department was murder and attempted murder.
Yes,
You had come to the exact same conclusion yourself earlier,
indeed.
and now your boss also comes to the same conclusion after reading the dockets.
Yes,
Now, the funny thing here is a withdrawal doesn't mean the end of the prosecution. You can reinstate if you find the evidence at a later stage.
yes,
After Mr. Ngasana left, there was another NDPP who was Mr. Sean Abrahams.
yes.
Did he reinstate the charges of murder against Mr. Mdluli?
No,
After Mr. Abrahams, there was another NDPP, Advocate Patoi, who seems to have been concerned about the withdrawal of the case. Did she reinstate the charges?
no, she did not. That's why I make it in my statement there to say, even as I'm sitting here today, she has never taken that decision to charge Mdluli with murder and attempted murder.
Yes, and does murder prescribe?
No,
Yes. So she had 7 years to charge Mr. Mdluli if she believed that there was a good case against him, and she didn't.
indeed.
Yes. Sorry, you wanted... Sorry.
Just to follow up on that one. Advocate Batohi, in her evidence and also even in her affidavit, she states that you weakened the murder charge by delaying prosecution. Are you able to help us understand what that means in the context of your work as a prosecutor?
No, to the contrary. One was able to determine whether that theory or the circumstantial evidence would stand scrutiny in court, which it was not. So she's saying directly the opposite, because the opposite will also be true, that at the inquest, it could be that the evidence there will come and show that indeed this circumstantial evidence is strong, and then it's the only inference that can be drawn that Mdluli who killed Ramokhibe at the exclusion of any other person.
Can you enlighten us about what could weakening a case mean, especially in the context of your exercise of your obligations as a prosecutor? Instances where we can really point out that indeed these are factors which can contribute to the weakening of the case at the hand of the prosecutor.
You will find the rare instances of that happening, because in a case where a witness is subjected to double cross-examination, that is cross-examined at the inquest and then being cross-examined in the actual trial, there is a potential that you think that the witness may contradict themselves in the subsequent trial and the like. That's the only reasoning that I think maybe she was thinking about it.
Yeah,
Anything more than that, it will be a figment of an imagination that will happen.
Okay, thank you, sir. Thank you.
Thank you.
Okay, Toby, I'm reminded that it is tea time.
Yes.
But before we pause, let me just clarify with the witness. Following the letter by Advocate Ngasana, or decision, let me not refer to it as a decision, 6A-161, where he said, please take note that the state is not in a position to proceed with the murder and attempted murder charges against Mr. Mdluli at this stage due to the lack of evidence implicating him. You said that this is a nolle prosecute decision. You understand it to be that?
Yeah, I understand it to be there at that stage.
Now, what avenues were or options were open to Advocate Batohi if she was of the view that the murder and attempted murder charges against Mr. Mdluli should have been proceeded with?
If she had evidence which would have come to light between then, when Mr. Ngasana made this decision, and her coming into office. She will be entitled to reinstate the charges, to make a decision to say the murder and the attempted murder charges should proceed.
That's where my problem is. I don't understand this sentence to mean withdrawal.
Yes.
I understand this sentence, and correct me if I'm wrong. The decision Advocate Ngasana is taking here is not a withdrawal.
No.
It's a nolle prosecute decision.
Yes.
Now I'm asking you, in the face of that kind of a decision, in your understanding of criminal proceedings, what options was then open to Advocate Batoyi if she was of the view that the prosecution should have been proceeded with?
It was to go back to the court and ask for the court to review the decision and consider factors that she would have had in a position to indicate that that decision was unlawful or was irregular. In the same vein that Freedom Under Law went to court to challenge the decision not to prosecute, she could have done exactly the same way to indicate that she wants that decision reviewed, and then that the court will consider and make a decision.
But the Freedom Under Law one was different because yours was a withdrawal.
Yes.
Not a decision not to prosecute.
Yes.
Is my understanding correct?
Correct, Chair.
Here, it is a final decision, if I may call it that, not to proceed with the prosecution.
Yes.
And in that instance, anyone who was of the view that prosecution should have been proceeded with would have taken certain steps. And you say Advocate Batoyi should have gone to court to review this decision of Advocate Ngasana.
Yes. Or Freedom Under Law then, when the decision was made and they were not satisfied, they would have approached the court for them to challenge that decision of Mr. Ngasana.
Yes, Freedom Under Law is not before us. There's no complaint by them. The complaint is by Advocate Batoyi.
Indeed, Chair.
Yes. We have now crossed that first hurdle regarding the withdrawal by you. The SCA has pronounced on that. The matter has now gone to Advocate Ngasana, the NDPP, in whose hands the matter was, and he decided, I am not proceeding.
Yes.
That should then have brought the matter to an end.
Which is what has happened. The matter was concluded then.
Thank you.
Thank you, Madam Chair. Sorry.
Just seeking clarity. Yes, the matter was then brought to a halt by the nolle prosecute, as my sister has stated, that, I mean, there is a clear difference between a withdrawal and you cannot exercise certain powers in respect of a withdrawal. Is it also not so that maybe the only option open for a person, not just focusing on Advocate Batoyi, because then we'll talk about her office later if necessary. Once a certificate of nolle prosecute has been issued, is it correct that those who have an interest in the matter would then have a right to institute private prosecution proceedings?
Yes.
But looking at the office held by Advocate Batoyi, would that, even that, be open to her? because people go for private prosecution because they think or they believe that the prosecutor has failed to exercise its decision properly. And the decision that comes from the NPA becomes the decision of the NPA.
Yes, she's functus officio.
She's functus officio, and
Yes.
she would not, that would also not be open to her.
Yes.
Thank you.
Yes.
Just the last question. On that aspect of the terms of reference, reference term 3.1.2,
I'm the chair.
if I may quickly just read it, the failure to continue with charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Tefo Abel Ramokhibe, in that he, Adv Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramokhibe and related charges to be withdrawn.
Yes.
We have crossed that hurdle.
Yes.
Notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter. We also dealt with what seemed to have been relied upon by Advocate Hali and others in the opinion that gave rise to this issue. Is there any other evidence, in your view, apparent from the affidavit of Advocate Batoi, other than what we have read in the opinion of Advocate Hali, suggestive of a strong evidence?
No, Chair. Even from the prosecution team themselves, they've never used this word strong evidence. They said there was circumstantial evidence.
Well, we will probably have the benefit of hearing from Advocate Batoi if she decides to come back and take that stand, or from any other witness who may assist us in establishing whether indeed there was such strong evidence referred to.
Indeed, Chair. It would be nice to hear the legal mind of Advocate Shamila Bato in that respect.
Yes, thank you. I don't know whether you want to close this chapter or you want to deal with other aspects. If you want to close it with few questions, maybe we should do that so that you can lap into the last few aspects of your case, if necessary.
Yes, Madam Chair. No, it's just to go back to the prosecution memorandum, which is the source of this. It's actually at RM 00883. The witness points to the fact that the charge talks about strong evidence, and it is disconnected from the prosecution memorandum, which is the basis on which they are relying. Now, if you look at item 1 under issue 2, strength of the state's case, it says the case on the murder charge relies solely on circumstantial evidence. Those include a threat by the accused to the deceased family that the deceased will be killed. Now, then, if you look at item 4, which is actually, I think that actually the attempted murder charge is irrelevant because it's not in the charge. The only issue to be concerned with is the murder charge.
I take it when they say and related charges, when you read the terms of reference, that's how.
No, but where do they say related charges?
Where they say a charge of murder relating to the killing of Mr. Tefo Abel Ramokhibe and related charges to be withdrawn.
So you would read related charge to be murder and attempted murder?
Yeah.
Okay, well, we can take that generous view. But then in paragraph 4, we are still back to where we started, paragraph 4 of the prosecution memo. It
Yes.
says the attempted murder charges, count 13 and 14, are also based on circumstantial evidence.
Yes.
So this is where the disconnect is. And then you look at the charges, the charge then invents a phrase, strong evidence.
Yes.
But that was not the opinion of the prosecution team.
Yes.
Yes. Madam Chair, I'm just going to do literally the last 3.2, which are the conclusions, and then I would like to stop so that we can have enough time for the cross-examiners. So if I could just do that quickly in 5 minutes before we adjourn.
Counsel, I think you should then finish.
Yes,
on
thank
this aspect.
Thank you, Madam Chair. If I can take you back to your terms of reference.
I'm there, Chair.
So in paragraph 3.2, they say, whether in fulfilling his responsibilities as Director of Public Prosecutions, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority, and is fit and proper to hold this position and be a member of the prosecutorial service. What is your answer to that? Did you comply with the Constitution? Did you comply with the NPA Act? Are you fit and proper?
Fully. I complied fully, and I'm fully fit and proper.
Yes. 3.2.2, whether Advocate Chauke properly exercised his discretion in relation to instituting and conducting criminal proceedings on behalf of the state, carrying out any necessary functions incidental to the institution and conducting such criminal proceedings, and discontinuing criminal proceedings. Did you properly exercise your discretion in relation to those 3 aspects?
Yes, Chair, I did.
Yes. Then whether you duly respected court processes and proceedings before the courts as required by the applicable prescripts, and as a senior member of the National Prosecuting Authority, did you respect courts?
I respect courts directly opposite to those who came before the inquiry, because they don't respect the courts.
Yeah, well, they're asking you to revisit court findings, so that says a lot.
Yes.
And then whether you exercise your powers or performed your duties and functions in accordance with the prosecution policy and policy directives as determined under Section 21 of the National Prosecution Authority. Did you respect the prosecution policy and prosecution policy directives?
Yes, I did, Chair.
Whether you acted at all times without fear, favor, or prejudice. Did you act without fear, favor, or prejudice?
Indeed, Chair.
Yes. Whether he displayed the required competence and capacity required to fulfill his duties by, among others, objectively engaging the facts presented to him impartially, in good faith, and without fear, favor, or prejudice, subject to the Constitution of the Republic of South Africa and the law, in order to discharge his duties as a Director of Public Prosecutions. Did you fulfill your functions in accordance with the required level of competence and capacity?
That's my view, that I fully complied with that.
Yes. And then whether he acted in a manner which brought the National Prosecution Authority into disrepute by any of his actions or omissions. Did you bring the NPA into disrepute?
Not at all.
Yes. Now, I understand that you've obviously not been happy that you've been suspended and you've been subjected to an inquiry and you feel there's a lot of unfairness.
Yes.
But the fact of the matter is that if you are not found guilty, you have to go back to the NPA.
Yes.
And you have to work with some people that you would feel have been unfair to you. Advocate Karen van Rensburg is one of them that you've specifically mentioned. I don't know if there are others, but Advocate Batoy is gone, so there is no issue there. But you have to work with people that you feel have caused you wrong. What is your view on that?
No, it happens in life and in work environment that you will differ as colleagues, and then work must continue. There's really no issue.
Yes.
Yes.
But you will be happy to go back and to continue with your work without any feeling of animosity.
Indeed.
the President should not be concerned that this act of suspending you and taking you to a disciplinary hearing has somehow impacted your ability to fulfill the functions as the Director of Public Prosecutions?
Not at all, except that in terms of the life outside there, and family and whatever, that this obviously they also would like it to be concluded. And if it's concluded that indeed I'm innocent and the like, the President had to follow this due process for him to be able to make a determination, and I've got no quarrels in that.
Thank you, Madam Chair. I have no further questions for the witness.
What are you saying about family?
Once you're being accused for almost 7 years, you're in the media, you are corrupt, you are captured, there are these decisions that it affects everybody around me to say, really, are you that corrupt? What's happening? And they're like, then you have to explain yourself over and over again. And that at times you sit with them and then you look through their eyes, you can see that they are so much worried about this conduct and the like. But now that this inquiry, since the start of this inquiry, and they hear that there is nothing about me being corrupt and all sort of things, there's just is that burden and all sort of things, and to me as a person as well.
You must be happy that the President agreed to institute this, to establish this inquiry.
Indeed. Everybody around me, they said that this is the best that could have happened, because if this did not happen, I just maybe decided to resign, to leave, and what have you. The truth that South Africa knows now, they would not be in a position to know.
Well, this panel has not made any decision thus far.
Yes.
But at least South Africa has been listening.
Yes.
And your family has been following these proceedings.
Yes.
Listening to witnesses.
Yes.
And making their own view. But this panel has not made any decision whatsoever.
Yes, I'm now referring to my family, and I like to say to them, this has been a good opportunity, and that has presented them with the opportunity to really see what is happening and understand from that background.
Because they've listened to the witnesses who testify.
Yes.
Thank you.
Thank you, Madam Chair. I've got no further questions to the witness.
You are closing your case?
Well,
I mean,
after
insofar as this witness is
so
concerned.
far as this witness is concerned, yes. I'm going to close my case very soon, Madam Chair. I know that I should.
Yes, that ends the evidence in chief of Advocate Chauke. We will take a tea break. Now that I have difficulties in working upstairs, we'll take 30 minutes.
Thank you, Madam Chair.
Yes, thank you. We will reconvene at 10 past 12. Good day, everyone. Good day, Advocate Chauke.
Good day, Chair.
You continue to be under oath.
Thank you. I confirm, Chair.
Advocate.
Thank you, Madam Chair. Good day, Tatana Chauke.
Good day, sir.
How are you?
Fine, thanks, and you?
I'm okay. You read documents. As you indicate in your document that you presented before this tribunal, you read quite a number of documents. We don't have to go back to them.
Yes.
Now, in your role as a coordinator, Did you have to read so many documents and dockets as well?
Yes.
The reason being?
When I had to assist Advocate Jiba in the review application, which was brought by Poison.
To assist him by giving him a briefing. Maybe if may explain that?
When there was a review application brought by Johan Poison, Advocate Jiba had to file an opposing affidavit in respect of that matter.
Okay, apart from that, Advocate Chauke, you indicated in the document that you presented before this tribunal, documents that you read.
Yes.
Were all the documents that you read that you are indicating that document for the purposes of briefing Advocate Jiba?
Settling the affidavit with counsel who was preparing the opposition to the application by General Johan Poison.
Okay, let's go to page 3 of the document.
Yes, I'm there, Chair.
You are there. These are the documents that you read. Monetary awards for Poison and Katomana unit. And date of document was the 14 October 2008. Was that for purposes of the review application?
Yes.
Okay. The High Court application by Bongani Mkhize, was it also for the High Court application?
Yes.
As well as the last one on that page, the meeting of 9 March 2012 with DPCI at the NPS head office.
That is a meeting, sir.
Yeah, but you indicating that there's an email down that you indicate there. There's a bullet.
Yes.
Now let's go to the next page. I'm not going to refer to each and every document. You have done so in your evidence in chief. All these documents that appear on this page, page 4, were for that purpose as well.
Yes.
To brief Advocate Jiba in the review application of General Poison.
Yes.
Okay. You also read the DeCock report on page 5, not so?
Yes.
That's also for that purpose.
No, sir.
Okay. Let's proceed. Now, in your evidence in chief, Advocate Chauke, you told this tribunal that Advocate Batohi purged black prosecutors. You remember?
Yes.
Did he only charge black prosecutors with misconduct?
In relation to Katomani?
Yes, in relation to Katomana.
Yes.
Was there no colored in the mix?
Colored, as I understand it, is black.
Was there no Afrikaner
Not that I'm
in the
aware
mix?
of. Not that I'm aware of.
Okay. Did Advocate Batohi ever show any, before that, if she, according to your evidence, she purged?
Colored, you mean people of mixed race?
That's what I mean, Madam Chair.
Thank you.
If you say she purged black prosecutors, are you suggesting, correct me if I'm wrong, that Advocate Batohi is racist?
No, I'm not suggesting that, but that she's racist or not, you may check with her, because when she was interviewed for that job, she was asked about this racism, and she had an answer then.
She had an answer?
Yes.
That she was not a racist?
I
Or
don't
what,
know.
what was her answer?
I don't know to what extent was the answer, but I remember her saying that she was surprised that there were those allegations against her.
Were you part of the panel that interviewed her?
No, I was also interviewed. I
For the-
watched the interview.
I see.
Yes.
Okay. Did she ever show any, when you were colleagues, did she ever show any tendencies of being racist towards you?
Towards me?
Yes, you in particular.
No.
No, thank you. I'll proceed to other issues. From your short resume, Advocate Chauke, one can decipher that you possess a wealth of skill and experience as a prosecutor, not so?
What is the meaning of decipher?
I could make out
Oh, okay.
from your short resume.
Okay.
Do you agree with me?
Yes.
You possess a wealth of skill and experience, which is commendable.
Thank you.
Now, let us take this general scenario. As a prosecutor, in particular as a DPP, after you shall have investigated a case, it's a general scenario, you should teach me if I don't get it right. You then prepare an indictment which is accompanied by a prosecution memorandum. Is that correct? Am I?
No.
How do you go about it?
About what?
About
Are you asking
pros-
just a general question about his prosecutorial function generally, or in relation to a specific matter pertaining to this inquiry?
I'm asking about a general scenario where an accused person has to be arraigned in the High Court. After investigation shall have been done, before you prepare an indictment, up to the stage of indictment, you then prepare an indictment and then a prosecution memorandum. How do you go about it?
No, if a prosecutor prepare an indictment to arraign a person in the High Court or in the Regional Court, there's no prosecution memorandum.
At what stage do you prepare a prosecution memorandum in a normal course of events?
When you want somebody other than you, a DPP or NDPP, to make a decision.
I see. Let me direct your attention, Advocate Chauke, to paragraph 117 of your statement. Which you'll find on page 6-32.
117.
It's on page 6-32.
Yes, I'm there.
For the sake of the record, I will read it yet again, because it was already read. You say there, on or about 11 June 2012, I met with Mr. Beekman of IPIT and Advocate Matenjwa to review the status of the investigation. And on or about 12 June 2012, I convened a meeting with General Mabula and the prosecution team to discuss updates. On the same day, I received the draft indictment and supporting summaries prepared by the prosecution team, unquote. You see that?
Yes.
Now, from whom did you receive the draft indictment?
From the prosecution team.
In particular, from whom in the prosecution team?
I don't remember, but the head of the prosecution team was Advocate Mayema.
In the same sentence, in the same paragraph, you refer to supporting summaries. I'm lost here as to what supporting summaries mean. If you can explain to this panel, what are supporting summaries?
The prosecution memorandum.
Which you also received from the team, the prosecution team.
Yes.
The sentence as it reads and as it is understood mean that you received the prosecution memorandum and the draft indictment on the 12th of June, 2012. Not so.
Yes.
Go to the next paragraph of your statement, that is paragraph 118 at page 6-33. I propose to read it into the record. It says, on this day, my personal assistant, Mamiki Suping, emailed the draft cover letter to acting KZN DPP Advocate Mlochwa. He had been acting in this position since December 2010, unquote.
Sorry, Councillor, which paragraph is that?
118, Madam Chair.
118.
Yeah, on the next page, 6-33, just at the top.
Oh, thank you.
If you say on this day, we should understand it to mean the 12th of June, 2012. Not so.
Yes.
You state in this paragraph, Advocate Chauke, that you sent a draft cover letter. You emailed, your PA emailed, personal assistant emailed the draft cover letter. I'm confused. Can you direct this panel to what you refer to as a cover letter?
I refer to the indictment that she sent together with that covering letter that she emailed to him.
By a covering letter, you referred to the email that your PA, Mrs. Suping, sent to Advocate Mlochwa.
Yes.
You call that a covering letter.
Yes.
Let's go to it. Let's go to the covering letter and see what covering letter you are referring us to. Do you know where it is located? If you can assist.
From where I'm sitting, I don't remember. From where I'm sitting, I don't remember. I can't locate it. Just
You can remember.
Yeah.
Okay, fine. We will locate it. In fact, you mentioned it elsewhere in your affidavit. You referred to the mail exchange between yourself and Advocate Mlochwa, which appears in paragraph 144 of your statement.
Yes,
If you can go to
even the
6
following
fo-
paragraph, even the following paragraph, you read 118, you read 119. That's the follow up to that.
Yeah, we're trying to locate the email exchange, where the email of your assistant appears. You mentioned the page there in paragraph 144 as B00574. Now, if we go to B00574, which is in bundle B2, Madam Chair. It starts in bundle B2, but specifically it goes to B3. 577, it's found in B3.
I'm there.
Now, go to the previous page. That's where Mamiki Suping's email to Advocate Mlocha is located. Do you see that?
Yes.
And it says subject indictment, Katomana.
Yes.
There was no message from Mamiki Suping. Not so. There's no
Yes.
message here.
Yes.
Which one is a covering letter that you say was sent? Because there's no message here, according
you are
to
reading there.
how we read this.
What you are reading, that email, is a covering letter that I'm referring to.
It's a covering letter.
Yes.
Now, if you go to paragraph 119, remain on the same page. Remain on the same page, Advocate Chauke. If you go to 119, you're saying there a disagreement subsequently arose regarding the sufficiency of the documentation, with Advocate Mlocha refusing to sign the cover letter in the absence of the prosecution memorandum or the original case dockets.
Yes.
Was Advocate Mlocha refusing to sign a cover letter, or was he refusing to sign an indictment?
The indictment.
You made a mistake by saying cover letter
Yes.
because it's incorrect.
Yes.
I don't want to say you are lying. No, I will not say so. It's a mistake.
No, it's okay. I can accept if you say I'm lying.
I'm not going to say that because I respect your office. And now, let us try the best of our ability to find whether the indictment that you sent, that you say you found from the prosecution team, was actually received from the prosecution team. And in this regard, my colleague will assist me here to find evidence of Advocate Maema when he was under cross-examination and see what he said. If Madam Chair can bear with me, let me be assisted by Advocate Mtsweni.
Yes, what are you locating? Maybe we can help.
It's a transcript of day 30. Transcript of day 30, where Maema was under cross-examination. Dated 20 February, Madam Chair, February 2026. Where Advocate Maema was being asked about this indictment. Which one is it? Start them again. On page 45 of 194, if you can go there.
Page 35.
45, Madam Chair,
Oh,
of 194 of the transcript of day 30.
yes, thank you.
Advocate Mtsweni was asking questions, and he started as follows. Yes, and you then said, from the week of the 27th May, you were attending in Durban on a weekly basis. Advocate Maema said, that is correct. Advocate Mtsweni, and at that time, you were still busy sifting through all these dockets. Advocate Maema, yes, we were analyzing the docket, guiding the investigations. Advocate Mtsweni, yes. Advocate Maema, yes. Advocate Mtsweni, you had not taken the decision to arraign anyone. Advocate Maema, that is correct, yes. Advocate Mtsweni, and you had not drafted any indictment. Advocate Maema said, that is correct. Advocate Mtsweni, right? So therefore, if anyone says, and you said the decision to arraign, when you then decided to arraign was taken, you then said you took the decision to arraign people on the 29th of June. Do you recall that? Advocate Maema said, that is, I recall that. Advocate Mtsweni, yes, and that is when you then embarked on the process of drafting the indictment. That is correct, yes. That's Advocate Mtsweni, and his Advocate Mtsweni says, and therefore, if anyone says that prior thereto you had drafted an indictment, that would not be correct. Well, as the prosecution team, Advocate Maema, the prosecution team, remember, the indictment is progressive. So we concluded drafting it, yes, towards the end of June. Advocate Mtsweni, yes. Advocate Maema, 2012. Advocate Mtsweni, but before the end of June, there was no indictment that was ready to be signed. The answer from Advocate Maema was yes, yes. Now, which indictment did you send to? Because according to which you sent to Advocate Mlochwa, because according to Advocate Mlochwa's testimony, I'm sorry, I beg your pardon. According to Advocate Maema's testimony, as at the 12th of June, there was no indictment yet.
No, Madam Chair, I need to object. My learned friend must read 46 and 47.
6 and 47 of
the transcript, Madam Chair, that he stopped reading. If he's going to suggest to the witness that as of the 12th of June, there was no draft indictment, he must read 47 and 46 and 47 and 48 of that cross-examination.
We do not have the benefit of our transcripts here right now, but we will rely on what you read, on what you have, Advocate Mutlamonyane.
My learned colleague says I should read also 47 and I say 47 and 48.
Yes, I'm just asking my learned friend to continue what he was doing, but through 46, 47, 48, 49, because this issue of the 12th of June was exhaustively canvassed with Advocate Mayema.
Perhaps you can look at the transcript, the 20th of February 2026, that you said you are reading from, and you referred us to page 45 of 194. Are you suggesting he must continue to page 46, 47, 48?
Madam Chair, it actually ends at 49. So I thought he was going to read through all of them, and then he stopped somewhere, which might not create a correct picture, but I don't want to make accusations at this stage. But he must just continue the line he had started.
Would you like to pause a bit, Advocate Mtlamonyane, and read pages 46, 47, 48, 49? If you consider that to be helpful, you can read it into the record so that we can also follow.
I'm comfortable to do that, Madam Chair. I ended at page, must be 47, where Advocate Mayema said, yes, yes. I'm continuing. Advocate Mtsweni says, now I'm asking this because if we turn back to Advocate Chauke's affidavit, he said, quote, on the 12th June 2012, I received a draft indictment with summaries of the matters from the prosecution team. I forwarded same to Mlochwa through my PA, unquote. And the question was, do you see that? Advocate Mayema, where? Advocate Mtsweni, paragraph 75. Advocate Mayema, oh, 75. Yes, it talks about a draft indictment. Advocate Mtsweni, yes. But you just told us that you had not finalized the indictment at that point in time. Advocate Mayema, it was, well, if there would be an indictment, it would be unfinalized and it would be a draft indictment. Advocate Mtsweni, but then let us go and see and hear what Advocate Chauke says. Advocate Mayema, okay. Advocate Mtsweni, he says, on the 14th June 2012, I attended the meeting at VGM NPA office with NDPP. In that meeting, arrangements were made that Mayema will sign the indictment, unquote. Advocate Mayema, I see that, Chairperson. Advocate Mtsweni, yes. Now, meaning that the indictment, in his view, was ready to be signed. Advocate Mayema, no, it does not mean that. Advocate Mtsweni, yes, but then let us go on. Are you aware that he sent the same indictment to Advocate Mlochwa, asking Advocate Mlochwa to sign the indictment? Advocate Mayema, I became aware here in the inquiry. Advocate Mtsweni, yes. Advocate Mayema, and I also heard the exchange during that was referred to in the state capture. Advocate Mtsweni, and that was despite you, the prosecution team, not having finalized that indictment. And the chairperson interceded there and said, sorry, before you answer, let me understand. Are you pegging that question on paragraph 76? Advocate Mtsweni, yes. It follows that to say, well, he says he received the indictment on the 12th, and then on the 14th, he was making arrangements for that, for Advocate Mayema to sign the indictment with Advocate Jiba. Now, I'm saying to Advocate Mayema that on his version, they had not yet finalized the indictment, and yet Advocate Chauke is already making arrangements for the indictment to be signed. Chairperson. But should you not have regard to paragraph 75, where he says, that is Advocate Chauke. He received the draft indictment? Advocate Mtsweni, yes. Chairperson, yes. Advocate Mtsweni now intervenes. Chairperson, on 12 June. Advocate Mtsweni, that is correct, Madam Chair. Chairperson, yes. So what is the point that you are making? I just want to understand clearly what our point is. Advocate Mtsweni, that document being a draft, and according to Advocate Mayema, it not being a final document, Advocate Chauke was already making arrangements for it to be signed. It appears to be ending there. This must be page 49. I'm not sure whether I read the whole thing that my learned friend has referred to, but I'm amenable to read it.
No. I don't want necessarily. The only point is I was objecting to the question that Advocate Mayema's evidence is that there was no draft indictment on the 12th of June. That's the only objection.
So, Advocate Chauke, that
Let's deal with the objection. You hear what the objection is. Do you wish to respond to what Advocate Ngcukaitobi is saying after reading those pages? Because we have to make a ruling on the objection.
if can I respond, Madam Chair?
Yes, sir.
If there was a draft indictment, I would concede, I would accept it.
Are you suggesting there was none?
I'm not.
So as at the time when Advocate Mayema testified, there was a draft indictment, according to you?
Yeah, if what we read here, that an indictment being a progressive process, I will then accept that there was a draft.
Meaning what you were putting to the witness was incorrect?
Not necessarily, Madam Chair. Not necessarily incorrect. Because he says he sent an indictment.
Yes.
But if it is a draft, I'll accept it is a draft. And then I'll proceed with my questions, further questions.
Well, the email B00578 simply says indictment, which was sent by Ms. Shuping, I suppose at the instance of Mr. Chauke, to Advocate Molochwa.
Yes.
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 And Advocate Chauke speaks of the events of the 14th of June, 2 days later. Is my reading correct?
Yes, Madam Chair.
At that meeting, it appears, an intimation was made that, or an arrangement was made that Mr. Mayema will sign the indictment.
On the 14th,
At the
according
meeting,
to,
yes.
of the 14th
This
June
is what was made, said at the meeting of the 14th of June,
2012.
2012. Is it unreasonable to assume that that which is mentioned at B00578 in that email might have been a draft?
It is not, Madam Chair. It is
Yes.
not unreasonable. May I proceed with my questions?
See, we are dealing with the objection, so I think Advocate Mchweni, if you can maybe give him a chance to listen first so that we deal with this issue. We cannot leave the objection hanging, and when we are done with it, then you can confer with him. Yes, thank you. Yes, thank you. The objection is sustained pertaining to this issue about the indictment mentioned in the email communication to Mr. Mlochwa and the subsequent testimony by Advocate Maema relating to the meeting of the 14th of June 2012. Meaning that that which was mentioned at the meeting of the 14th of June 2012 related to an indictment that had to be signed by Mr. Maema according to the arrangement. But that which was sent on the 12th of June 2012, 2 days prior, can reasonably be understood to have been a draft indictment that was sent at the instance of Mr. Advocate Chauke to Advocate Mlochwa. Accordingly, as I mentioned, the objection is sustained.
Thank you, Madam Chair, as it pleases. Thank you, the Chair.
You may confer with your brother.
Thank you, Madam Chair. Thank you, Madam Chair. May I proceed? So, Advocate Chauke, we may accept that the document that you sent to Advocate Mlochwa on the 12th June 2012 through your personal assistant, Mamiki Suping, was a draft indictment, not so?
Yes.
Do you sign draft indictments? Why must Mlochwa sign a draft indictment, which was not final, not so? It was not final.
Yes.
Why must Mlochwa sign a draft indictment?
For him to be appraised with the matter.
To be?
Appraised with the matter.
What is the purpose of signing an indictment, whether it be a draft or a final one? What is the purpose?
The purpose when you are in court is to place the accused before the court.
So had Advocate Mlochwa signed that document, it would have served before the High Court?
It would have been served before the regional court.
Or before the regional court?
Yes.
Okay. Now, I want to refer you to a document which I take was an indictment. And you should confirm whether it was the same document that you sent to Advocate Mlochwa. You will find it in B2, bundle B2, from page B00484. Madam Chair. It starts from 484.
Advocate Mhlamnyane, I don't mean to take you back, but you said something about Advocate Mlochwa signing an indictment. And that from the reading of paragraph 118, 6-33, Advocate Chauke says his PA emailed the draft cover letter to acting KZN DPP Advocate Mlochwa And we now know that the draft cover letter refers to the indictment. That's what he admitted to.
Yes, Madam.
But I don't see. Okay. Well, I'm reading now the second paragraph that says a disagreement subsequently arose regarding the sufficiency of the documentation, with Advocate Mloja refusing to sign. But also go back to the the transcript, because as Advocate Mthweni, while cross-examining Advocate Maema, there was an objection raised by Advocate Ngcukaitobi. I think on page 49, the last sentence there. And it had something to do with the question whether Advocate Chauke instructed Mr. Mloja to sign the indictment. Not sure if you saw that while you were reading. That would be, it's the last sentence at page 49 and goes to the first 2 lines on page 50. And unfortunately, we only have extracts, so I do not know what was the final decision on that objection. And I wouldn't want us to deal with an issue where an objection was raised and there was a pronouncement and we repeat the issue. If you can look past page 50, because I only have up to page 50, where Advocate Mthweni was, where the chairperson asked, that is why I asked you, who made the arrangements that Advocate Maema will sign the indictment, right? And then Advocate Mthweni refers to the same paragraph of the 14th of June 2012, but I only have three lines. That is, we only have up to page 50. If you can go up to page 51 and see how that objection, okay, thank you.
How it was dealt with.
How it was dealt with, so that we do not have something that was objected to repeated into the record. Thank you.
Yeah, on page 50, starting from page 49, where Advocate Ngcukaitobi SC said, Madam Chair, could I just ask my learned friend to point us to the page where Mr. Chauke instructs Mr. Mloja to sign the indictment? And then says, Chairperson, yes, I'm on that point because I'm lost. That is why I'm asking counsel to assist me. From when you read from paragraph 75, that is why I took counsel there. Advocate Chauke says, quote, on 12 June 2012, I received the draft indictment with summaries. I forwarded same to Mloja through my PA. And then it's written 76. On 14 June 2012, I, Advocate Chauke, attended a meeting at VGM head office. In that meeting, it is Advocate Chauke speaking. It's written Chaukas there, but I think it's a misspelling. Advocate Chauke speaking. Arrangements were made that Maema will sign an indictment. That is why I asked you, who made the arrangements that Advocate Maema will sign the indictment? Advocate Mtsweni. Madam Chair, he tells us in his affidavit that he attended a meeting. If one reads, I just want to get to the document again. He says at paragraph 76, quote, on 14 June 2012, I attended a meeting at VGM NPA head office with NDPP. In that meeting, arrangements were made that Maema will sign the indictment, unquote. So, meaning that the arrangement was being made between him and the NDPP. Chairperson, indistinct, microphone off. Advocate Mtsweni. Advocate Chauke, because he said he attended, he does not tell us that there was anyone in that meeting. It was him and the NDPP, because he says, I attended a meeting at VGM NPA head office with NDPP, and he does not tell us that there was anyone else. Yes. Chairperson says yes. Advocate Mtsweni, and then he says, at that meeting, arrangements were made that Maema will sign the indictment. Chairperson, yes. Advocate Mtsweni, yes. Chairperson, yes. What was your question? Advocate Mtsweni. And the point is that the prosecution team had not finalized the indictment, and yet Advocate Chauke is already making arrangements with the NDPP that Maema will sign. I will pause there, Madam Baloi Mere, SC, and you may indicate as to whether it's enough to the extent to which I've read.
I'd like you to go further because at page 52, Advocate Mtsweni then went on and said, because the objection was not dealt with, Advocate Ngcukaitobi still persisted with the objection, and Advocate Mtsweni then retracted the question. Oh, sorry, I'll repeat. My microphone was not on. I'm saying if you proceed to read the text that you were reading, when you go to page 52, because the objection was not ruled on, Advocate Ngcukaitobi persisted with his objection. And then Advocate Mtsweni's response was, no, Madam Chair, I retract the question. It was a mistake. I should not have said that. And then he went on and said, I retract that question and that statement. I did not mean to put it that way. I just wanted to say he forwarded the indictment to Advocate Mlojwa. The issue here was that it seemed like Advocate Mtsweni wanted to pursue a line that Advocate Chauke sent the indictment and said to Mlojwa, sign the indictment. But when he retracted, he left his statement at, I just wanted to say the indictment was forwarded to Advocate Mlojwa, and he left it there. Sorry. That is why when I started, I said I do not want us to deal with an issue where an objection was raised and an objection was ruled on. In this instance, it was not ruled on, but Advocate Mtsweni retracted his statement and rephrased his statement so that we do not go back and forth on the same statement that was then reformulated. Thank you. Thank you, Chair.
Thank you, Madam Chair. Do you allow me to proceed?
Yes, maybe, perhaps, when you look at the retraction by Advocate Mtsweni, then, as my sister has just mentioned, we have gone back to the point. It will probably help you if you go to the emails.
Indeed. That's where I wanted to go. Thank you, Madam Chair.
I have to go there with you.
Please do so. And refer you to
keep record of what was being read to us. The records that we were given is up to page page 50 only. And fortunately, my dear sister does have a further record of that day. It will help if Advocate Monyani were just to tell us as to up to which page and paragraph did he read or line. At least we will have that on record and proceed as you are doing, Chair. Please.
Thank you, Madam Ramahaha. My colleague will help me here. I'm not even sure. What page is it?
Page and line. Up to which page and line of the transcript?
I read up to page 52, Madam Ramahaha.
Page 52.
And let me just find out as to where no, in fact, it was 51. Can you help me out? I think it was 51. I made a mistake. Yes.
I went to page 52.
Yes. Yes. What line, if you can assist? I don't see lines here.
From line 9.
Thank you, Madam Baloi Mary, for rescuing me.
Thank you very much. Through you, Chair, it will help, especially if what we don't have is being read out, that we just be given the information so that we record at our own time we can read that. Thank you, Chair.
Thank you, my sister. We've gone back to that point. We've gone back to the issue of objection. What my sister was telling you, because we are not here when Advocate Mchweni was cross-examining Mr. Maema, he retracted the questions.
I've seen the retraction, Madam
And
Chair.
we accepted the retraction. I was saying earlier to you that the retraction by Advocate Mchweni is consistent with the record when you look at the emails. So I was going to take you to those emails. If you look at the chronology or the sequence of those emails from page B00578, which Advocate Ngcukaitobi dealt with, you'll see in those emails, the first one is the one at B00578, where Ms. Mamiki Suping sends an indictment.
I see that, Madam Chair.
The evidence is that that covering letter contained it was a covering letter of the documents which included the indictment. You accepted earlier that we can reasonably assume that it was a draft indictment. This is on the 12th of June, 2012. When these documents were signed, sent to Mr. Mlojo. Now, there is no way where Advocate Chauke or the email of Mamiki Supin says sign the indictment. There is no way. Now look at the subsequent email by Mr. Mlojo himself, the same day at 3:21 p.m.
The one on page B00577.
Yes. The bottom of that document
I'm there, Madam Chair.
up to the next page. You want to read it?
I think it's already on record, Madam Chair. It's not necessary to read it. But
I
if
just
you
wanted to close this
yeah.
line of questioning, because then we have to close it. We all ruled over it, but it is clear that that which was discussed at VGM on the 14th, where arrangements were made on the 14th of June that Mr. Maema will sign the indictment, was subsequent to this exchange.
Yes, Madam Chair.
You see now the third email on the same day by Mr. Mlojo.
Yes, I see. The one at the bottom, the one written in...
No. The first one was the first one on B00578. You see that first email?
From Mamiki Suping?
Yes.
I see it.
On the 12th of June. Look at the time there. It's 1:29. The response from Mr. Mlojo was at same day at 3:21. On the same day, Mr. Chauke writes to Mr. Mlojo. You see the third one?
I see it, Madam
You
Chair.
see the third one?
Yes, I see it.
From these communications, there is nowhere where a suggestion was made that Mr. Mlojo must sign.
Will you allow me to respond after you shall have?
I'm asking you whether, is there anywhere in this communication where Mr. Mlojo was told to sign?
May I take Madam Chair and the panel to the third communication by Advocate Chauke and refer you to the last but one paragraph.
Yes.
If you permit me, I can read it into the record.
You may read it to the record.
It says, and I quote, it came at 5:14. He was responding to the one that from Advocate Mlojo that came in at 3:21 p.m. And Advocate Chauke at 5:14 p.m. says, among others, the following, and I quote, "Another issue of concern to me is the delay in you issuing the instruction of the reopening of the inquest in view of the fact that you have been requested to sign the document, which must be preceded by a decision to reopen the inquest." I'll leave it at that, unquote. It would appear from what Advocate Chauke is saying here, Advocate Mlojo was required to sign the document, the indictment.
Do you read that from the first email by Mamiki? Because that's when documents were sent to him for the first time. And Advocate Mlojo then responds and says, "Give me a memo or report." You see that?
Yes, I see that, Madam Chair.
The third email must be read in the context of the second email. You can't read that in isolation. You see the second email at the bottom of B00577. There was an exchange there. Mr. Mlojo responds to Mr. Chauke, where he says, "Kindly furnish me with the prosecutor's memo or report so that I can have a wraparound views of the matter. The report must also have the police stations and case numbers so that we can open up the DPP's file." Then it is that long email by Mr. Maema. I see the point that you are addressing. After this third email, you had just asked the witness about the arrangements made on the 14th of June at VGM, where Mr. Maema arrangement was made that Mr. Maema was asked to sign the indictment. That's where you ended before the interruption by my sister.
Yes, and there's a point, if you allow me, Madam Chair, on the second, the responding email of Advocate Mlojo on page 00577B005, where in paragraph 1, it would appear that he had had a conversation, a telephone conversation with Mr. Advocate Chauke. I just wanted to place that on record, that he has responded through before he wrote this email. But be that as it may I proceed with my next question?
Madam Chair, I really hate objecting when counsel is cross-examining. But it has to be clear what point is being made here. The original point made by Mr. Mtweni was that Advocate Chauke instructed Advocate Mlojo to sign the indictment. Is that the same point that is being made by my learned friend now? And if so, I would ask that he shows us where the instruction from Mr. Chauke to Mr. Mlojo to sign the indictment appears.
Are you persisting with the point, Counsel?
Madam Chair, I'm not persisting with the point that there was an instruction to sign, because it was retracted. The point I'm persisting with is the one that appears in the paragraph that I have read, that you were requested to sign.
Yes.
That is the point, which is a version of Advocate Chauke.
Yes. Advocate Chauke may address that point in your letter of the 12th June at 5:14. The third email of that day. It is B3, Voicens 3 of 11, at page B00577. You remember I mentioned that there were 3 emails on that day. The first one was by Maniki Suping at page 00578. It was followed by the response by Mr. Mlojo at 3:21. That signals that after receiving these documents, he communicated with you. You had a telephonic discussion. And then after that email, that is after 3:21, at about 5:14, same day, you wrote to Mr. Mlojo. At paragraph, the last but one paragraph, you made mention that he had been requested to sign the indictment. You can address that point.
To address, what is the comment? May I make comments or what?
Yes.
What is the question?
The content of that last but one paragraph.
It's correct that I wrote that email to Advocate Mlojo.
I'm referring you, Advocate Chauke. Counsel, I'm referring you to the last but one paragraph of your email, the third one, the one at B00577. You have that? That
Yes.
long email.
Yes.
Look at the last but one paragraph.
Yes, I see that I said I requested, he has been requested to sign the indictment.
Yes, he's dealing with that aspect that Mr. Mlojo was asked to sign that draft indictment, correct, Mr. Mlojo?
Correct, Madam Chair.
So I'm asking you to deal with this aspect.
Maybe I'm misunderstanding the question. It's correct that I wrote and conveyed to Mr. Mlojo that he should sign the direct indictment before the inquest can be reopened.
Yes. Now, the point that was made earlier was that how could Mr. Mlojo be expected to sign a draft indictment? You remember the indictment that was sent to him of the 12th of June, which was sent by Ms. Shuping,
Yes.
was a draft. And a point was made that how could he be expected to sign an indictment which was a draft? And you answered that he had to familiarize himself with what was contained in the indictment.
Yes.
It emerges now that in your email to him, after your communication, your telephonic conversation with him,
Yes.
you then wrote what you wrote at that last but one paragraph.
Yes.
Meaning, if I understand your answer, you expected him to sign a draft indictment.
Yes.
Now, his question earlier on was how could he be expected to sign a draft indictment? Am I correct?
Yes, Madam Chair.
Yes, thank you. Are you able to answer that?
Yes. That's why I indicated that draft for him to sign it would lay the basis for him to be able to reopen make application to reopen the.
May I proceed, Madam Chair?
Proceed, sir.
earlier on I said I want to refer you to a document which apparently is that draft indictment, but you will confirm whether it is the one that you sent to Advocate Mlocho. Let me direct your attention to the index to folder B, poison, to the index number 32, which shows draft indictment at B00484. It says undated draft indictment, and then the page it gives us B00484 up to and including B00529.
Are you referring to the index of Boyson's 3? Because there's Boyson's 1, 2, 3, up to 11.
B2, Madam Chair.
B2.
Yeah, B2, bundle B2. It's numbers.
Yes, I'm at 00484 now.
On the doc.
Yes, I'm at 00484 now.
On the document itself, or are you on the index? I'm referring first to the index. Let's start there.
Which page is the index?
Maybe perhaps it's page 3 of the index. And item 32.
Please assist there and give the witness the document and show him the number. It's number 32 at page 3.
Yes, I see that, Chair.
Yes. And it is 32 undated, draft indictment B00484 to B00529. Is that what you are referring the witness to?
Indeed, Madam Chair.
And he went to that document. Is that what you want him to do?
That's where I wanted him to start. Now, you see that, Advocate Chauke? You see that, you are there on page 3.
Yes.
Fine. Now, I want you to go to the page itself, 484.
Yes.
Are you there?
Yes.
Fine. You see there, it's a document that reads in the High Court of South Africa, in brackets underneath there, Peter Marisbeck.
Yes.
It says, it reads as follows, and I'll read only the top portion. It says, the Director of Public Prosecutions for the South Gauteng High Court, Johannesburg, who prosecutes for and on behalf of the state, hereby informs the Honorable Court that, colon, and the names of the accused there. The first one is Mr. Paul, and their ages are not mentioned there. And then it goes on. So this is an indictment, not so. Go to page 2, the next page, 485.
It is a draft indictment.
Yes, getting there, Madam Chair. My apologies. It's a draft indictment.
Yes.
Okay. Go to the last page, Advocate Chauke. 521. It's B00521.
Yes.
That document there, it's in your name.
Yes.
Can you explain that? The reason why it is in your name as the DPP South Gauteng?
It was drafted by the prosecution team, Advocate Maem.
Not yourself.
No, sir.
Is this the draft indictment that was, which you requested Advocate Mpofu-Walsh to sign?
No.
Is this one?
No.
It's not this one.
No.
It's another one.
Yes.
Similar to this one.
Yes.
Okay.
That will be in the name of Advocate Mpofu-Walsh, not in the name of Chauke.
Which one?
The one that would have been sent to Mpofu-Walsh.
I see. But maybe I'm confused. Just help me out here. You are the DPP in Gauteng, in South Gauteng.
Yes.
A matter is supposed to be prosecuted in KZN,
Yes.
but a draft is done in the name of South Gauteng.
Yes.
Why should that be?
Advocate Maema was here before the panel. He explained that he was doing the draft cut and paste. He explained, was he?
Yeah, maybe he might have explained, but
Yes.
I ask you to explain to me.
I can't explain to you something that I did not draft.
You see, the difficulty with this Advocate Motlamonyane is that you were not here when Advocate Maema testified and when he was cross-examined by Mr. Mchweni. If you go back to the transcript, I hope you had an opportunity to read the transcript. This aspect was dealt with by Mr. Maema, and he explained all that as to why Mr. Chauke, first of all, his office was used, and then they drafted document, and he signed some of the documents to send them to the NDPP. So probably you'd have to ask your colleague to take you to the transcript and familiarize yourself with what Advocate Maema's evidence was. Because we don't want to go back to that evidence and then rehash what he said. I do accept that you don't have the benefit of his evidence because you were not here. But if you say to me you have read the transcript to familiarize yourself with the evidence, I will accept that.
Madam Chair, I will accept that we should not rehash. Allow me to proceed. We should not rehash the evidence that has been...
Have you read the transcript?
Not that part. I didn't have time to read that part. And if it has been dealt with extensively, I will pack it and proceed with other matters, other issues.
Yes, but what helps is that when you are not here, when a particular witness led evidence and you'd like to ask questions pertaining to that witness, whose evidence you have not had, for you to read that.
That is why I say, for the sake of saving time, allow me to proceed with other questions. If it has been dealt with extensively, I'll accept. And there's just no time to go to the record now, and because it's going to take time. We're going to waste time, the panel's time. I'm amenable to proceed with other questions and leave this issue that has been extensively dealt with.
I'm not stopping your cross-examination. I'm saying to you, and I don't want you to just abandon the point because it may well be a very important point. I'm simply advising that familiarize yourself with the transcription, the contents of the transcript, before you proceed, so that you know precisely what transpired during your absence, so that you don't go back and forth and try to tell you what happened because your colleague was sitting here alone and you are now cross-examining a witness about something that you didn't even, you were not even here when this particular evidence was led. And it's taking us back to the transcript. And you can see now they are bringing our files from the office because we did not anticipate these questions. And I'm advising you again, read the transcript before we proceed so that you know what happened when you are not here. You may proceed, sir.
Madam Chair, in that event, I will ask for a short adjournment to go and familiarize myself with that portion of the transcript.
No, I think you can park this question so that we can make progress. We will note it. I wouldn't just like you to abandon it. And tomorrow when you proceed, you can go back to this aspect because you would have read the transcript.
As it pleases you, Madam Chair. I'm advised by Advocate Mutshwane that it may be lunch break. I don't know what time was arranged for lunch recess.
I don't know. Advocate Mutshwane, I have to confer with my colleagues. I even forgot that there's things called lunch. Just a minute. Yes, thank you, Madam Chair. It's indeed lunchtime. We've gone beyond lunchtime. We have gone beyond lunchtime. We will adjourn now. Advocate Chauke will pause from now. It's about 1:45. We'll take a 45 minutes lunch break.
Thank you, Chair.
We will adjourn until 2:30. Good afternoon, everyone. Good afternoon, Advocate Chauke.
Good afternoon, Chair.
Advocate Mutlamuyane, you may proceed.
Thank you, Madam Chair.
I acknowledge, sir, that, Chair, that I'm still under oath.
That is the beauty of working with advocates.
Thank you, Chair.
Counsel. Thank you, Counsel.
Thank you, Chair.
Thank you very much. You may proceed, Ndate Mutlamuyane.
Thank you, Madam Chair. Advocate Chauke, we are still on page B00577.
May I recap?
Thank you.
And remind me, where is 577?
It's in B3, Madam Chair.
B3.
Yeah, it's part of the exchanges, email exchanges between Advocate Molocho and Advocate Chauke, the one that we're busy with before the lunch recess.
Yes, thank you.
If you can go to the last part one that we read before we adjourned, the last part one paragraph in that email of the 12th June 2012 at 5:14 p.m., which you addressed to Advocate Molocho. You remember the first sentence was read. Now I'm going to read the second sentence. It says, if this makes you uncomfortable, please indicate so that I may urgently take the matter up with the acting NDPP as well as the minister, unquote. It's you addressing Advocate Molocho. Let me ask you this. Advocate Molocho refused to sign the draft indictment that you sent to him, not so?
Yes.
Did that pose a problem to you and the prosecution team by his refusal to sign?
No.
But you threatened to report him to the NDPP, to take the matter up with the NDPP and the minister.
Yes.
Which minister were you referring to?
Minister of Justice.
Why should it be taken to the minister?
It's because that was a high-profile matter and the minister was always being briefed and the NDPP about that matter.
Were you going to report to the minister that Advocate Molocho was refusing to sign?
No.
What were you going to report to the minister?
To indicate his reluctance to cooperate.
To cooperate?
Yes.
If you go back to B00578.
Just to make a follow-up on that point so that we can have the context. And correct me if I'm wrong, Advocate Chauke. From the record, it appears that the reason why Advocate Jiba got involved in this arrangement is after the newspaper publications and the minister had communicated with the former acting NDPP, raising a concern that these matters are urgent and that they needed to be enrolled or prosecuted, something to that effect.
Yes, Chair, my understanding is that the police, General Mabula, and them would have approached the NDPP the acting NDPP then, with this urgent request, which they would have discussed with their minister, who is the Minister of Police.
And this matter ultimately landed on the table of the Minister of Justice.
Yes.
Then Minister Haarzavi.
The Minister, Honorable Jeff Haarzavi, yes.
Yes, and that led to him communicating with the former NDPP, acting NDPP, Advocate Jiba,
Yes.
requesting that these matters should be urgently dealt with.
And that he should be updated because he was apparently also appearing in Parliament where he was supposed to answer to this.
Could that have been the reason why the minister was then involved about the reluctance or the non-cooperation of Advocate Mlojo?
Yes, especially in respect of the issue of the inquest.
Thank you.
Go to page B, 00578, the previous page, Advocate Chauke. Madam Chair has already referred us to that communication from Advocate Mlojo. If you go back to it to refresh ourselves, to refresh our memories, paragraph 2 thereof reads, that was when Advocate Mlojo was responding to the draft indictment that you had sent him. And he says, kindly furnish me with the prosecutor's memo or report so that I can have a wraparound view of the matter. The report must also have the police station or stations and cast numbers so that we can open up the DPP's file. Thanking you in advance. Best regards, Simpiwe. You would surely agree, Advocate Chauke, that what this advocate is saying in this paragraph does not reflect a person who does not cooperate or who is recalcitrant or who refuses. He merely says, please, send me the memo.
Yes.
Now, why do you say he was uncooperative?
The context of the email I'm requesting, I'm referring to the inquest, the reopening of the inquest.
Was he uncooperative as far as the opening of the inquest are concerned, or was he uncooperative as far as the signing of the draft indictment was concerned?
The reopening of the inquest.
You requested him to reopen inquests.
Yes.
I would have gone to inquest at a later stage, but let me hasten to get to the inquest that you are now referring to, so that you can enlighten us as to exactly what was happening. What is it that Mlojo was refusing to do? Go to page No, it's the same document, same exchange, email exchanges, but revert to 577. You respond to his email of 3:21 p.m. at 5:14 p.m. and you're saying to him, Dear Advocate Mlojo, who is the prosecutor that you are referring to? I forwarded to you the indictment, which has all the detailed summary by which you ought to be in a position to open your office file. I also forwarded to you details of the inquests with police cast numbers, etc., to which you referred to Advocate Togoma Jokweni for reasons that I do not follow and understand. the indictment with respect gives you the whole view of the matter, unquote. Now, which inquests are these? Can you explain to this panel what inquests you were referring to so that we can know what you're talking about?
Catomania, unnatural deaths.
So in the Katomana killings, if I may use that pun, in the Katomana killings, some of the dockets, some of the cases were referred to magistrates to hold inquests.
Yes.
The magistrates finalized those inquests.
Yes.
And what in the majority of the cases, what were the findings of those magistrates?
That nobody is responsible for the killings of the deceased.
Those decisions that exonerated the police who fired shots or who killed those victims, those decisions, are they judicial decisions?
Yes.
Which are contained on a document called the J56.
Yes.
Now, procedurally and legally, if you open such a judicial finding, how do you normally go about it?
You prepare a report, you submit it to the NDPP, who must submit it to the minister and the JP.
Judge President.
Yes.
Now, for them to place them before a judge.
Yes.
If I may, so that I don't forget this point, Advocate Mutlamunyana, I don't want to disrupt your line of questioning. The inquest in relation to the Katomena matters, I'm just remembering from the reading of the transcript, and correct me if I may be wrong. You remember there were statements that we read earlier to the effect that the police or investigating officers, and correct me, I'm not sure who really did that, but it appears that the referral for inquests in those matters were made by the police themselves.
The police would have submitted the case dockets to the DPP's office, and the DPP's office would have made a decision to say, in this case, inquest must be heard and submitted to the magistrate. In that case, the police will go back and then take out the statement from the case docket and then prepare an inquest docket which will be submitted to the magistrate.
The inquest dockets would have been prepared by the police themselves.
Yes, and submit them to the prosecutor, and the prosecutor would go through them and then submit them to the magistrate for the latter to hold the inquest.
I just want to know if you remember in relation to which cases. If you do, if you don't, I'll request counsel to probably just list those cases so that we can determine the contents of those dockets, in relation to which decisions were then made that there should not be any prosecution, something to that effect.
Yes, indeed. I cannot remember them a list from the top of my head, but remember yes. When Ms. Shamila Williams was testifying, she alluded to some of them, those where the inquests were held, and some of those where the inquests were not held, the investigations were just not pursued.
Yes. Advocate Mutlamunyani, have you familiarized yourself with that piece of evidence so that we can refer us specifically to this to these matters, because it is important as you ask these questions
Yeah, I will.
to look at that. That may necessitate further questioning
Yeah, Madam
following
Chair.
your question.
At the moment, I can't remember them from the cover, from my top of my head, as my learned colleague is saying. I did read them some time ago. I may revisit them and list them and find out which ones were they. But I remember there were inquests that were held. If
What is important for me is to ascertain what was contained in the investigative dockets for referral for inquest, because that is important before we even come to that conclusion. So if you can ask your colleagues to assist you before you finish with your cross-examination, refer us to the relevant bundles.
I may not be able to do so now.
And I'm
To the
saying, ask
yeah.
your colleagues. Advocate Mchweni is not here.
I'll ask Advocate Lekgetho.
Yes, Advocate Lekgetho can note that we request that we be referred to the relevant part of the docket containing the investigative dockets for referral to inquest. Because those dockets would have been prepared by the police and would like to see who did and what the contents of the dockets were. If you may do that, Advocate Lekgetho, and give Advocate Mutlamuyani that information before, either today or tomorrow, before he finishes. Then we can look at those relevant parts of the record. Thank you. Proceed.
Thank you, Madam Chair. What's
Through you,
to
Chair, just before I'm going to ask a general question. Advocate Chauke, you, in your responses to Advocate Mutlamuyani's questions, you have now spoken about the criminal case dockets and the inquest dockets. Now, in general terms, who would have called for the establishment or the creation of inquest dockets? Who has the power?
The DPP and the staff working at the DPP's office, deputies and senior state advocates.
So the power to even enable or direct the police to open an inquest docket rests with the prosecution.
Yes.
The police cannot, of their own accord, create an inquest docket.
No.
Yeah, maybe I'm asking you this question or these questions because of what is already on record. And part of what is on record, I don't expect any of the parties to dispute that, but if it's in dispute, then we've got to get the records that will show that that is on record. What we have on record here is that there are those case dockets which would be marked as inquests right from the beginning. And at that time, those dockets would not have been seen by the prosecutors.
Yes.
And I think you are the right person to can also enlighten us about that, because Ms. Williams also did enlighten us, but you being right there as a prosecutor, and as you tell us, is the prosecutions that has that power to direct. What do you say about the fact that the dockets that were spoken about, especially by Advocate Williams, was that right at the scene, as the matter is being reported, that docket that would be opened, it would already be marked inquest. Well, what do you say about it?
No, police usually do those things, but it's not here, not there. That even if it's written inquest, it still has to the prosecutor, for the prosecutor to determine whether it's an inquest or a criminal prosecution should follow.
So the label does not confer the powers.
No.
The powers remain with the prosecutor in terms of the NPA Act.
Yes.
Thank
And
you.
even in terms of the Criminal Procedure Act, the
Yes.
prosecutor must first read the statement and determine whether the criminal prosecution should follow or an inquest should be directed.
Yeah, then in conclusion, that means that the power to undertake inquest would be derived from the prosecution.
Indeed.
Thank you.
You may proceed, Mr. Matlamanyana.
Thank you, Madam Chair. Maybe to take it to some conclusion, go to page 5B00573. It's B2, I believe. Yeah, must be B2. Bundle B2.
Page?
00573, Madam Chair. It's a communication by Advocate Chauke to Advocate Mpofu-Walsh, dated the 13th June 2012 at 11:20.
That should be volume 3, not 2.
I got it at
B3.
B3. Thanks for that. I thought it's 2. Thanks. Are you there, Advocate?
Yes.
You then write to Advocate Mpofu-Walsh the following day. 00573, B00573. It's an email addressed to Advocate Mpofu-Walsh. You write to him the following day. Remember, the previous day you had said to him, you are taking exception, maybe. I'm just saying it in broad outline, not necessarily that you said those words, but that you were not satisfied. You were not happy that he was not reopening the inquest. You remember?
Yes.
Now, the following day, on the 13th June 2012, you write to him, you say, kindly take note that I hereby withdraw the request for you to consider reopening of the inquests which have been listed on the memo. There will be no necessity for them to be reopened at this stage. I would, however, request copies thereof to be made, and the current investigating team will approach your office or the offices of the magistrates for such assistance. I will let you know if we are unable to get assistance in this regard, unquote. You know about this?
Yes.
So you were no longer requiring him to reopen them.
Yes.
But did you follow up with the magistrate's offices?
The prosecution team and the investigating team would have done that.
Would have done that?
Yes. Not me.
Not you. But
Yes.
then, prosecutions followed in the Katomana matters, not so?
Yes.
Were the inquests reopened?
No.
They were not reopened.
No.
Were they not supposed to have been reopened before the prosecution team could proceed with prosecutions?
No. I realized I came to, once I've discussed it with the prosecution team, and then I went through, and then I realized, no, it won't be necessary because we are not going to do inquests. We are going to do prosecutions.
But in some of those prosecutions, there were already judicial pronouncements made
Yes.
on the predicate offenses, not so?
Yes.
But you continued to charge the officers
Yes.
on those predicate offenses on which magistrates have already pronounced and exonerated those officers
Yes.
from blame.
Yes,
Is that allowed in law?
very much so.
Thank you. Now, I'll park this issue of the inquest for now. I'll get to the issue of you being a coordinator. And I direct your attention to your statement in the Zondo Commission, which you can find at LO1 bundle, LO 00296. That's where it starts. In fact, it starts at LO 00243.
Mr. Advocate Mhlamyane, please pardon me. You asked a question whether this was allowed. And Advocate Chauke said, yes, it is allowed in law. And I think you left us all hanging. Wouldn't it have been better to take it further so that we know which law? Because, well, for me, I'm left hanging. Advocate Chauke says, yes, it's allowed in law, and you seem to let it go, unless if you accept and you know the law, and I'm left hanging.
No, I did not want to elicit argument with a witness. I intend to leave this for argument. Yes. Because if I say the law says this, he's going to say no, the law says this. I wanted to avoid arguing with a witness, Madam Mary.
You said LO1 page?
It's 296. It's actually 00243.
Yes, Chair, I'm there.
Madam Chair, I thought I have it here. I asked my colleague, Advocate Lekgetho, to get it for me. I thought I have it here. I don't have it, and she will locate it for me electronically. I thought I have a hard copy. I have it somewhere, but I'm missing it now.
I'm trying to restrain myself, Counsel. You have had a weekend. I would have expected the evidence leading team to have used the weekend to prepare bundles, or at least a document, a file, for the purpose of cross-examination. And you can see how difficult it is. We now get documents far away from our researchers as you are cross-examining. Was it not possible for you over the weekend to prepare for this cross-examination?
I thought of it, Madam Chair, but because I tried to avoid preparing bundles, because most of them actually that I referred to are already on record. And I had spoken to Tate Moirani and informed him about the ones that I'll be referring to, but my apologies that I can't locate this one. I tried to avoid bundles, preparing a bundle.
But you are creating problems for yourself because you refer us to documents, we locate them ourselves, but you, the one who's asking the questions, don't have it. So preparation would have been helpful to you and also to us so that we can pack all the relevant documents behind us.
Through you, Chair.
If that may assist you, do you have a free document that you can give to Advocate Mhlamyane? if it is possible. It is LO1. You have it.
I have it, Madam Chair. It's an electronic one.
It would have been helpful if Advocate Lekgeto could be sitting next to you. Tomorrow you must make those arrangements so that she can be closer and to help you, especially in locating the documents that you are using.
Thank you, Madam Chair. I
Thank you.
appreciate it.
Through you, Chair.
It's as they go to.
Advocate Mohlamunyane, I'm just bringing it to your attention because I don't know whether Advocate Motsweni told you, Advocate Lekgeto told you, and whether you are aware. Just to avoid what happened earlier today, just to sensitize you to the fact that I trust that you are aware that on the 20th day of February 2026, Advocate Motsweni did ask questions, put questions to Advocate Maema regarding this matter. It is just sensitizing you to that, especially regarding the fact that of what happened earlier on, that, you know, you'd ask questions apparently maybe without being aware of anything.
This particular witness statement.
I'm just letting you know that. On the 20th of February, when Advocate Maema was in the box, Advocate Motsweni questioned him. As to what it is all about, I can't give you the details. What I'm aware of is that he did ask questions, put questions to Advocate Maema on that day. You can continue. Thank you, Chair.
Proceed, Advocate Motsweni. Oh, Advocate Mohlamunyane.
Thank you, Madam Chair.
I'm sorry to refer you to as Advocate Motsweni.
It's private,
Following
so in
my
any event.
sister's cautioning. My apology.
Go to paragraph 60.
Paragraph?
Paragraph 60, Advocate.
60.
60, yes. It's on page 266.
Yes, I'm there, Chair.
It starts with, Jiba requested me to assist with putting together a prosecution team which will guide members of the police and members of IPID, the Katomana team, on the investigation and prosecution of the matters. I agreed to be the coordinator of the prosecution team. The prosecution team was comprised of the following advocates. We already know who they were. My concentration will be on you being the coordinator. Now go to paragraph 62 of the same document.
Yes, I'm there, Chair.
You set out your role as team coordinator. Now 62.1, you say you deal with the logistics and administrative matters of the prosecution team. 62.2, you say ensuring coordination between the various stakeholders. 62.3 says my involvement excluded taking prosecutorial decision whether to prosecute or not. And 62.4 says feedback and briefing on the team to Jiba, including the submission of documentation from the prosecution team to the NDPP. You confirm that, not so?
Yes.
Now you continued to sing the coordination song. In other words, you continued that you were the coordinator, and even in your current statement before this panel.
I was not singing, Chair, I was talking.
I beg yours?
I was not singing.
I'm sorry. I beg your my apologies. Maybe I used a wrong pun, but my apologies to you, Advocate.
Of course
Thank
you
you.
did. Ntate Motlhamonyane, issues of
The law.
sensitivities are very important
Yeah,
to all of us.
I agree, Chair.
I cautioned earlier that you are all advocates, and you need to treat one another with the utmost respect and observe the decorum of this inquiry. We as a panel give you the utmost respect, all of you. And you are legal practitioners, you must respect one another, as you do as officers of the High Court or of the courts. Please do that.
Thank you, Madam Chair. I reiterate, I apologize. Go to your own statement, Advocate Chauke. Go to page 6-26.
Which own statements? You were talking about the one at the Zondo Commission, and there is a statement that I made here.
No, in this inquiry, I've moved away from that one. Sorry if you do not hear me, but the statement that you made for this hearing.
Thank you.
Yes.
Go there. You had just referred him to another paragraph. Was that 64? When you said that he
Yes.
continued with his song?
I was getting into his own statement that he made before the inquiry. The one
Not
that-
a paragraph in this Zondo Commission affidavit?
No, Madam. No, Madam Chair.
Which paragraph in his statement?
Let me start with paragraph 89 on page 626. The last sentence in paragraph 89 reads as follows. My role was limited to that of oversight and coordination in support of the prosecution team. You see that? Eh?
Yes.
Go to 91 on the next page, the last sentence that reads, that position was conveyed in the course of my oversight role.
Yes.
Go to 92, the same page. The last sentence reads, my role was to oversee the process at the request of the acting national director.
Yes.
Now, my question is, coordination and overseeing, are they synonymous?
Yes.
It's one and the same thing.
Yes.
Now, go to 99 on page 6-29. That's correct, Madam Ramachaka. You say in that paragraph, my role in the matter arose following a request by the acting national director that I coordinate and oversee the work of a prosecution team drawn from outside KwaZulu-Natal. My involvement was therefore supervisory and coordinative in nature.
Yes.
Coordinative, supervisory, overseeing, do they mean the same thing?
Yes.
They mean what you have listed in paragraph 60, 60.62, 62.1, 62.3, 62.4 of your affidavit in the Zondo Commission.
Yes.
Your role was supervisory.
Yes.
You were the supervisor, in other words,
Yes.
if we have to use that noun. You are supervising the prosecution team.
Yes.
You are not managing the prosecution team.
Yes.
Yes to what?
To the statement that you are making.
That we are not managing the prosecution team.
Yes.
You are overseeing it.
Supervisory and managing is one and the same thing. I don't know if we're going to play with those semantics of words.
We have to address them because you are saying you are the coordinator, and we need to know what were you doing when you were coordinating.
I understand.
Yes. Go to LO4. Please, just give him LO4, page 00886.
Ye-
00886.
Yes, I'm there, Chair.
You will see that in that document, it's an email that you send from your iPhone to Dr. Ramaite.
Yes.
By the way, remind us, what position was Dr. Ramaite holding at this date when you were sending the email on the 11th of April 2014?
Was Deputy National Director of Public Prosecutions and Head of National Prosecution Service.
NPS.
Yes.
You say in this document here, in this email, "Good day, Dr. Ramaite. I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Katomana matter. I also refer to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Mahema, and the DPP KZN, Advocate Nogo. Regards, M.A. Chauke, Director of Public Prosecutions, South Gauteng, Johannesburg." You are referring to management here.
Yes.
Is this coordination?
Yes.
Does this management and prosecution mean coordination?
Yes.
Now, why did we have to read dockets if we were coordinating? Why did we have to get into the trouble of reading all these dockets, so many dockets?
I did not read all the dockets. I listed the dockets that I've read in respect of the review application, which the NPA through the NDPP was opposing.
Would you agree that management involves more than mere coordinating?
No.
Do you also agree that your involvement went beyond mere coordination? You were managing.
No.
I have no further questions, Madam Chair.
Thank you, sir.
If I may just follow on the last question, and if you don't intend to do so, feel free to say that. I would imagine that the evidence leaders could probably have evidence to the contrary, to suggest that Advocate Chauke actually played a role more than that of a coordinator, but rather of a prosecutor taking a prosecutorial decision, because that is the key issue here. And we really seek to make a determination to that effect, and if you can assist us, if there is probably any evidence to that effect that you can take us to demonstrate that in actual fact you were not simply a coordinator, but rather a prosecutor who took prosecutorial decision. First, in relation to the Kato Mena matter, and second, in relation to the Mdluli matter. But as regards the latter, there is no issue because he has just testified this morning that as far as the Mdluli matter is concerned, he's the one who took a prosecutorial decision. My concern relates to the Kato Mena matter.
Madam Chair, we would have pursued the issue of the prosecutorial decisions that we allege Advocate Chauke has taken. But we could read when Madam Chair said we have not, rather the issue of prosecutorial decision does not form part of the TOR. And we decided not to pursue that aspect because it's not there in the TOR. Because we would have pursued it in this fashion. All what he was saying, he did. We would have argued that it constitutes prosecutorial decisions. But since it has been indicated to us that it has not been alleged, we decided to abandon it, that aspect. Not to proceed to argue along those lines.
I'm not sure I understand what you're saying.
Maybe I should do it in this
Perhaps
fashion.
you must go to the terms of reference. I'm not too sure what you are saying, and I really need to understand the point that you're making.
That I'm making, yes, Madam Chair.
Because the terms of reference tells you exactly what is it that is alleged against Advocate Chauke. If you look, for instance, at paragraph 3.1.1.1, he supported a decision to prosecute the accused, notwithstanding that there was no evidence justifying the decision. And he sought to improperly have the acting Director of Public Prosecution, KZN, sign the case dockets and all prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made.
Madam Chair, I stand to be corrected. I just want to refer, Madam Chair, to, I think he was still being led by my learned colleague, Advocate Ngcukaitobi SC, when Madam Chair indicated that in any event, the issue of prosecutorial decisions that he would have taken are not part of the TOR. If it was not yesterday, it must have been last week, but it's somewhere on record.
I don't remember that. Do you have a transcript that reflects that?
Maybe we can check the transcript. Let me just check when it was done because I made some notes.
Because the point that I'm trying to ascertain with you, Advocate Maema, as the evidence leaders, and I really seek you to assist us here. If you are aware of any evidence that points to Advocate Chauke having taken any prosecutorial decision insofar as the racketeering case of the Katomena is concerned, please bring that to our attention because it will assist us. And I'm not sure what your answer is. If you are not aware of any such evidence, you have consulted with some of the witnesses? you are going to lead. Maybe you can draw our attention to the record, then we can look at that evidence. Because you could see this morning, Advocate Ngcukaitobi dealt with those aspects of the TOR to deal with this very specific issue regarding a prosecutorial decision insofar as Katomena is concerned.
Advocate Mhlamiane, I've checked my notes, and the only issue that the chair commented on was the issue of jurisdictional straddling. And I'll quote it as I've written it, it may not be verbatim. Jurisdictional straddling, although it does not arise in the TOR, but it was dealt with extensively when the Section 6 DPP was explained. That is what I have in my notes when Advocate Chauke started giving evidence. Thank you, Chair.
Do you remember that, Council?
Yes, I do remember that, and you correct me if I'm wrong. I remember that
Sorry, Madam Chair, if I can intervene. I know it's not my turn, but my learned friend's turn. But I think that it's incumbent upon us to just remember where we are. The question by the Chair is, if there is evidence that Advocate Chauke performed prosecutorial functions, that must be put to him. Thank you, Madam Chair.
In other words, as you have consulted with the various witnesses, whilst this witness is still in the witness box, it will be appropriate that you put those versions to him, if any. That's why I'm asking the question, because this is a very important part of this inquiry. Before we even make a determination whether there was evidence or not, the key point is, was there any prosecutorial decision made by him or taken by him in relation to the Katomena matter? And if there is such evidence, put it to the witness and direct the witness to that evidence so that we can hear his version in relation to that aspect. If any, of course. If I may, Council, I ask this question because you have gone into the various phrases used in the statement by Advocate Chauke, where he says, I was a coordinator, I was playing a supervisory role, I was exercising oversight, and I would like us to go to the real crux of the matter. Did he make any prosecutorial decision insofar as the Katomena is concerned, which pertains to racketeering? And if there is any such evidence, if you may assist us and put it to the witness whilst the opportunity is still available before he leaves that witness stand.
Yeah, may Thank you, Madam Chair. May I be afforded an opportunity to reflect on it, and then I will later proceed with it, maybe tomorrow.
The point is that are you going to proceed with your cross-examination, or would like us to adjourn?
Maybe
Because
adjourn.
that would have been an appropriate moment for re-examination.
I'll ask for an adjournment so that I can reconsider and then proceed with cross-examination along the lines which Madam Chair says I should pursue.
I see your junior seeks to talk to you. You may confer with each other.
Thank you, Madam Chair.
Yes, Counsel.
Thank you, Madam Chair. Advocate Lekgetho apprised me of the fact that perhaps I should let you know that it's Advocate Nicole Mayet who should deal with the Mdluli matter. Maybe she can start to deal with the Mdluli matter, and then I can come back later, if that is appropriate.
You seek leave to revisit the cross-examination in relation to the Katumena matter.
Indeed, Madam Chair.
Yes, we will allow you to revisit this matter before she finishes, or rather when she finishes with her cross-examination on the Mdluli matter. You can then come back to these aspects.
Thank you, Madam Chair, for the opportunity.
Counsel, are you not too far from us? It will be convenient for us to look directly at you if it is not inconveniencing you, or Advocate Mhlamunyana.
No, I will make way for her, Madam Chair.
Maybe as we rearrange our tables, we'll take a 10 minutes break to stretch our legs. And Counsel, you can take that chair, and we'll start when we resume. Or we'll start at 10 to 4. Advocate Chauke, we will pause for 10 minutes, and we will continue with you. At about 10 to 4, you are still under oath.
Thank you, Chair. Confirm.
Good afternoon, everyone. Good afternoon, Adv Chauke.
Good afternoon, Chair.
It's been a long day. It's been a long day. Counsel, you are under oath.
Thank you, Chair. I'm still.
Advocate Mayet.
Thank you, Madam Chair and the
You may
panel.
proceed, madam.
Thank you. At the outset, let me commence by apologizing to the panel for not producing bundles in cross-examination. I honestly labored under the misapprehension that such resources were not available. I apologize, and in the event that the cross-examination does continue to tomorrow, you will have bundles by tomorrow.
Or at the very least, a kind of a document that can guide us to enable our researchers to prepare the document timelessly.
Indeed. I take the
Yes,
point.
thank you.
The second
take note of
apology.
that.
The second apology is on behalf of Advocate Chauke. We did not anticipate that we would begin our cross-examination today, and she was given leave of absence.
Yes. But are you
I
in
am-
a position to start?
The issues, yes, I am in a position to start, Madam Chair. The issues are very narrow. What I propose to do, and my approach in this cross-examination, is to commence by assisting the panel by going to the terms of reference and adopting a process of elimination so that we can distill exactly which decision we are dealing with in clause 3.1.2. If you would indulge me with that. I know my learned friend has canvassed much of the 3.1.2 already, so it will not be a evidence in chief, but it's simply to so that we are all on the same page, because 3.1.2 is rather cryptic.
Yes, thank you very much. If you can speak louder. Thank you very much. If you can speak louder, Council. And yes, secondly, that roadmap will help all of us so that you know the areas of your focus.
Thank you, Madam Chair.
You may start.
Thank you. Good afternoon, Mr. Chauke.
Good afternoon.
Mr. Chauke, I would like to refer you to the terms of reference bundle, and it is on page 7 and clause 3.1.2.
Yes, I'm there, Chair.
Thank you, Mr. Chauke. Now, Mr. Chauke, when we read this clause, and I'll read it for you so that we can just distill it, it says, the failure to continue with charges against Lieutenant General Richard Ndluli for his involvement in the murder of Mr. Tefo Abel Ramogibe, in that he, Advocate Chauke, caused the charge of murder relating to the killing of Mr. Tefo Abel Ramogibe and related charges to be withdrawn. Now, if we just stop there, we know that the SCA judgment found that your decision is not irrational.
Yes.
And this decision was not appealed.
No.
And the MPA is bound by the SCA finding that your decision to refer to inquest was not irrational.
Yes.
So we can accept that up until 3.1.2 does not concern your decision of the 2nd of February 2012.
Yes.
And we also know that the SCA ordered the National Director of Public Prosecutions to take the decision post 2014.
Yes.
And we know that this decision was taken in April 2014.
Yes.
So we can accept that 3.1.2 does not concern the decision in April 2014 post.
Yes.
Thank you. Now, before we go further to find out what decision we are dealing with, I'd just like to take you further, staying on 3.1.2. It reads, notwithstanding that there was strong evidence justifying the institution of a prosecution in the matter, which decision caused a significant delay in proceeding with charges concerned. Now, it took me a while, but I referred to the judgment of the trial court. And you will find that in RM 1059.
Please repeat that.
It is RM
RM
1059. The judgment itself begins on RM 1047.
Sorry, is there a page?
1059. Um, 59, yes. 1059.
Yes, I'm there, Chair.
Thank you. And if you refer to line 1 on that page, if you could read it into the record, please.
So the delay, if any, started running from the 31st of March 2011 and 1 April 2011, respectively, when the two accused before the court were arrested, respectively. Only then did the delay commence. Let us then examine...
You can stop there. Thank you, Mr. Chauke. If I could then refer you to page 1063. And on that page, if you could go to line 14, if you could read what the trial court found.
It is not that one can... It is not that one cannot bring an application to challenge the decision of the NPA to prosecute an individual.
Sorry,
but in this case...
Sorry to interrupt you, Mr. Chauke. If you could
Madam,
just...
we have to go to those parts of the record that you're referring us to. Just take it
I
slowly.
apologize.
After referral to RM 01059, the top paragraph, which...
Then it is
the next paragraph.
RM 1063. 1063.
1063.
Yes. I do apologize. I was watching Mr. Chauke. Yeah, I am referring to line 14. It's the third paragraph. It begins with consequently.
See that?
Consequently, it cannot be correct for Mr. Mutloung to argue that because the murder of Opara Mokhebe occurred on the 19th February 1999 and General Mduli is only facing charges in June 2015. Therefore, there has been an unreasonable delay, and also that because the inquest absolved this client from any culpability, there cannot, therefore, be any lawful reason to prefer charges against General Mduli.
Thank you, Mr. Chauke. So we can accept that the period that we're talking about is post 2011.
Yes.
And if we could go back to the terms of reference, this 3.1.2, when I read this clause, excluding the your 2nd of February decision, excluding the later decision in April 2014, the only period that it could possibly refer to, given that the trial court found that there was no unreasonable delay for the longer period, it could only be after the inquest judgment on the 2nd of November.
Yes, maybe before the inquest judgment, because that's what I thought when Advocate Batoi testified. That's what she was referring to.
So you would agree that the period that clause 3.1.2 is concerned with is the period October 2011 to 2014.
I'm not so sure about that.
But it certainly commences from October 2011.
It will commence from November 2011 when I received the representations from adherents of General Mdluli.
You will recall that the representations from General Mdluli came on the 26th of October.
Yes, yes, I believe so. I thought it was in November, but yes.
When did you receive them? Do you remember?
Off the head, I cannot remember, but I accept what Council is directing me to the date in October.
October.
Yes.
Do you want to refer us to that part of the record? I know
it is simply the
I do in the record. Did you check that?
I do have it in the record, Madam.
We will make our own note. You may proceed.
Thank you, Madam Chair. I will return with that. I'll make a note of it. And Mr. Chauke, at that point you had been newly appointed. I understand you to have commenced in September 2011.
Correct.
And the NDPP at that stage was, if you could just remind us?
It was Mr. Menzi Similan.
And so we can accept that your decision, you made your decision in 2011 to refer the matter to inquest, and the inquest was done in 2012.
Yes.
And you received the results of the inquest on the 2nd of November 2012.
Yes.
Now, if I could refer you to the SCA judgment, and I'm told, and Madam Chair and the panel, I do apologize for my fumbling with the record. I have tried my best to make myself familiar, but it is in the court case bundle.
So, Council, which judgment were you referring to?
Pardon, CL 00362. That's the judgment of the SCA in the National Director of Public Prosecutions versus Freedom Under Law.
Thank you, Madam Chair. I'm indebted to you. Are you there, Mr. Chauke?
Which page, Chair?
It is 0062. 362.
Yes, I'm at page 00626.
And if we could turn to paragraph 44 of the judgment.
What paragraph?
44.
Yes, Chair, I'm there.
Thank you, Mr. Chauke. If we read the paragraph, it says, Fool's real argument, which found favor with the court arco, paragraph 183, is that Chauke's failure to proceed with the murder and related charges after the findings of the inquest became available was irrational. But that decision, or really his failure to apply his mind afresh to the matter after the conclusion of the inquest, was not the subject of the review application.
Yes.
So we can accept that as at the 2nd of November, you have the inquest report before you, and this is, by a process of elimination, presumably what 3.1.2 concerns, your actions and decisions in this period going forward.
I accept if that was you're telling me.
Thank you. I don't have any other interpretation.
Yes.
And we can accept that the judgment, if you also refer to paragraph 54, paragraph.
I'm there. It's CL00286. Are you referring to that one?
It is 371. It is 00371.
Yes, I'm there.
54.3a says refers to your 2nd of February 2012 decision. Do you agree?
Yes.
So, as at the 2nd of November 2012, we are not dealing with the SCA judgment.
Yes.
Thank you. Now, Mr. Chauke, because this is a commission of inquiry and we want to understand your thinking. So, and it's my duty to put what was before you on the 2nd of November, so that you can, the panel can understand what was before you. So, if you could just work with me, and I understand that you would have the inquest report in front of you.
Yes.
And you would have also had the heads of argument which your prosecutors submitted during the inquest.
Yes.
And you would also have had the docket in front of you.
Yes.
At that stage, FUL had launched its review application on the 15th of May 2012.
Yes.
And you had filed a record sometime in July 2012.
Yes.
But, and on the 26th of October, Mr. Mdluli General Mdluli had submitted representations to you.
2012?
It
Give
is.
us full dates.
It is the 26th of October, 2012.
Yes, thank you.
No. The representations from on behalf of General Mdluli came in October 2011, not 2012.
I will accept your better knowledge of this, but if I could just...
I think the document was referred to earlier.
Yes. It was referred to earlier, and the only question was whether it was October or November 2011. And Advocate Chauke said he doesn't remember, but he will accept your suggestion that it was October.
Yes. But
I understood then she was referring to October 2011.
Yes.
It could not be October 2012 because by then
we were awaiting the findings of the inquest, which came in November 2012.
I will accept your better knowledge of the it is 2012.
Yeah, I just want to address this issue of basing the acceptance on the better knowledge of the witness. It is my understanding that this inquiry is constituted mainly, or reliance is made heavily, of the documents that are available. And I want to believe that we all have similar information. I'm just trying to avoid a situation where again you will hear that, no, but you had said this. So you rely on what you have. You ask questions because you know answers to the questions.
I do apologize, Honorable Panel Member. The document you will find on RM 00338, and Mr. Chauke is quite correct that it is 26 October 2011. RM 00338.
Is it the representations by Mr. Mdluli?
Indeed.
Is it not RM 00881? You see the document marked AC5 earlier, and the document that was referred to by Adv Chauke is RM 00881. It's Mdluli Volume 4. If you are referring to the representation, RM Mdluli.
Madam Chair, perhaps there's a bit of a duplication.
Chair, I have it in RM2, the representations from Maluleke Sreti Matlala Incorporated. It was RM 00338.
Oh, 0000, okay.
008, 00338.
What was referred to was the prosecution memo in relation to the representation. Thank you. Thank you. Yes, you're correct. It's 338. You may proceed now.
Thank you, Madam Chair. So, Mr. Chauke, just to come back to see what was before you. You had the inquest report, the heads of argument, and the docket.
In November 2012.
In November 2012.
Yes.
After the inquest has happened.
Yes.
Because we already know that the period before that, the SCAA has said that your decision was not irrational.
Yes.
So we can only, by a process of elimination and purely to assist the panel when they examine the permutations of clause 3.1.2, it would necessarily concern your decisions that you made once you had the inquest report in your possession.
Yes.
And if we were to understand the underlying instruction that you gave to the magistrate, when we look at your letter of instruction to the magistrate, and that you would find on RM 178,
I said page?
RM 00178.
Yes, Chair, I'm there.
And if we look at this letter, it is dated the 14th of March 2012.
Yes.
And it is your formal request to the magistrate to conduct an inquest. Do you agree?
Yes.
And if you look at paragraph 3 of that instruction to the magistrate, you set out a list of names of witnesses.
Yes.
And the list is quite extensive.
Yes.
Amongst the list is, I just like to highlight this. Amongst this is the brother of the deceased. We find him at F. And there are also certain police persons, such as in M and in X.
Yes.
Now, this you can agree was the evidence that was presented before the magistrate.
Yes.
And if we were to look at that evidence, because we know, and I'm sorry to jump around, but as the SCA made the finding, the magistrates, the outcome of the inquest was somewhat peculiar, as the SCA said.
Yes.
So in November 2012, you have before you certain information, and I'd just like to explore your thinking. If I could refer you to bundle VR, it is the Vosloorus docket.
Give the full details of that case number, if you have it.
It reads, index to folder, Gluli case docket, Vosloorus CAS, 340/02, 1999. I will
It's a VR.
It is a VR. Where do we find it? Honorable panel member, I'm similarly very confused with the record, and I am reliant on my.
Where is Advocate Lekgetho?
I am told that because I discussed it with the researchers earlier, that they know exactly where I'm going and they will produce it.
Yes, I thought that you'll have the assistance of the NPA next to you, Advocate Lekgetho. Is she assisting Advocate Mutlamunyane? Where is she?
She is assisting Advocate
Advocate Mutlamunyane.
Mutlamunyane.
Okay. If you need assistance, our researchers will come closer to you and locate the documents that you need to use.
Thank you, Madam Chair. I do have the documents in front of me. I
Now.
just want to make sure that the panel has the documents
Yes.
as well as Mr. Chauke. I am referring to VR, and the page reference number is 000028.
It's phosphorus.
It is the phosphorus bundle.
2 zeros, 3 zeros,
It is 4 zeros.
4 zeros,
Madam,
28.
um,
Thank you.
Yes, I'm there, Chair.
may I proceed?
Proceed, madam.
Thank you. Mr. Chauke, this document which is before you, we can accept is the affidavit of Mr. Tefo Abel Ramochibe.
Yes.
And it is his complaint with regards to the attempted murder.
Yes.
And if we read the second paragraph, if you could please assist me and read it for us. I think your voice is better than mine.
On 1998-12 to, I think it's about 3 at about 22 hours 30 and 23 hours, I talked with Killer, one of the persons who is known to me, and the policeman at Fort Loras police station about the car, because I had a journey to Nelspruit, and he told me that he does not know the person who can borrow me the car, and I will. There is something missed there. He said he will give me his car and wanted an amount of 500 rand, which was paid to him. I was accompanied by Alfred and Patience. Patience stays at Nyashiho Street, second house to the right. And contact number is 804-6122. Alfred's we traveled to Killer's place and dropped him there. We were on our way.
And if you could continue to the next paragraph, please.
When we approached the stop sign next to a certain street at extension 9, I heard several shots towards us and saw next to a fence shooting at us. I did not stop and drove away towards street and decided to go back and dropped the two, and I went straight to deliver Alfred at extension 3 and later Patience at her place, and I decided to sleep at her place, where the following day I went to the owner of the car to report the matter, and they accompanied me to the scene of crime where 2 empty carriages were found, and then I decided to open the case at Fort Loras police station as case 475 of 12/1998, attempted murder.
Now, Mr. Chauke, earlier you testified that when you read the docket, you were of the view that all these people were friends. But reading this statement, there is no mention of, there seems to be quite a distant relationship. Do you agree?
Yes.
Now, on the same bundle, if you could...
If I may just clarify one aspect in relation to what was read into the record now, because I realize that you refer to portions and you do not pursue the point. What point do you seek to make in relation to the statement of Mr. Abel Ramochibe?
The point is, Madam Chair, that Mr. Chauke was of the view that he did not pursue the theory, as he called it, the theory of of the relationship, and that General Mdluli had a vendetta against the deceased because he was of the view that they were friends. They were all friends because there was a car that was lent, and that was my understanding. I will clarify, Mr. Chauke, was that my correct understanding of your testimony?
That he was having a cordial relationship with people who were associated with Mdluli.
But maybe just for clarification, who is killer?
It's Mthunzi, one of the accused.
Is it Qimba or Glo?
Qimba, killer. Yeah, it's a. Let me just get before I confuse the names now.
Is that the one who's mentioned at RM 00178C, Sebastian Nkosana Qimba?
Yes, his nickname is Killer.
His nickname is Killer.
Yes.
How do we know that? How do you know that?
I can just quickly go through the other statements where there is reference to him as Killer. I might not have it here, but that's what it was known.
So your counsel will accept your word for it. If so, we will search through the record.
Indeed.
Madam Chair, I will also endeavour to find the appropriate cross-reference. On that same bundle, Mr. Chauke, if we could turn to VR 4087, it is A19.
So when you say the same, the very same way where I was reading the statement.
The same bundle.
Okay. Same page?
The same, no, different page. If you could turn to page 87.
Whose statement is that? The statement is that?
This is the statement of Detective Lieutenant Colonel. I do not want to mangle her surname. Let me just. Oh. A19,
sorry. Colonel Ngobo.
Indeed, Madam Chair. Are you there, Mr. Chauke?
Yes.
Mr. Chauke, we can accept that this statement under oath, which, if I could just get directions from the panel, I'm not sure as to the agreement with the panel members. The statements which are contained in the bundles. Am I required to verify or prove them, or may I just allow Mr. Chauke to read from them?
Refer to them and the relevant parts thereof that you seek to rely on. And if you wish, you can read the relevant portion, or you can ask Mr. Chauke himself to read into the record.
Thank you, Madam Chair. Mr. Chauke, this statement, if I could refer you to the third paragraph, the fourth paragraph, and if you could just read into the record from the fourth paragraph, the fourth, the fifth, the sixth, and the seventh paragraph.
We used to talk when we drive, but that day Captain Matlala told me shocking story. She asked me if I was aware that the community of Fosoras came to the police and submitted the petition that demand General Mduli to be removed and transferred from Fosoras to other station. I told her that yes, I heard about that, but I don't know the reason. She said people said he is a murderer. I asked her how. She said there was a complaint who was shot dead while he was pointing out. He was pointing out the scene of crime where he was shot before. She, Matala, to me, that the firearm that was used to kill the disease was hers. I asked her how did a state firearm used to kill somebody. She told me that General Mduli told her to bring a gun to him. He will give her firearm to Mr. Killer Krimba in order to use it to kill that person. Matala said she gave a gun to General Mduli and he said he will arrange other firearm for her. By that time, Matlala was not having a gun. Matlala told me that the police officer that were with the deceased were Warrant Officer Domo and Warrant Officer Kulu. She said they were fully aware with the plot. She told me that the person who shot the deceased was Killer Krimba. She said she was told to report the missing firearm. I was afraid to ask her many questions. I was just listening her. I did not believe her. After a year, Captain Villagas from Fosoras, she phoned me asking the whereabouts. Captain Matlala asked her why she was looking for her. She said Matlala opened the case of lost firearm but was not circulated. Captain Villagas wanted her for that. I did not relate this story to anybody until 2009 when I told Inspector Makubo.
Thank you, Mr. Chauke. I am just, I beg leave for the panel's indulgence. I've lost my reference to the Hulu statement. To who? Mr. Warrant Officer Hulu.
Warrant Officer.
Whose name appears in the seventh paragraph. If I could just beg leave your indulgence to find the reference to that statement. It appears on VR 000498 to 504. Thank you, Mr. Chauke. Are you there?
Yes.
I know this is a long statement, but it is the last statement I will ask you to read into the record. I think it sums up the entire the case. It has everything, all the relevant details. If you could please read the statement.
From paragraph 1.
Yes, please, Mr. Chauke.
The facts deposed to hearing are true and correct, and save where the context indicates otherwise, fall within my personal knowledge. I am a warrant officer in the South African Police Services stationed at Germiston Detective Services. I can be contacted on that number and the cell phone number, that number. On 7 June 2011, I was interviewed by Colonel K.D. Rulof about an incident that happened in February 1999. In this regard, I refer specifically to the murder of one Opa Ramokhibe in Vosloorus. I joined the South African Police Service in June 1986 as a municipal policeman and was fully integrated into the SAPS in 1989. I continued working at Vosloorus SAPS as a uniformed policeman doing administrative work until 1994. I then applied to join the detective services at Vosloorus and started working as a detective in 1994. I was still a constable at the time. I think I left Vosloorus SAPS at the end of 1999 or the beginning of 2000 after I heard that there were posts available at the detective services at Bedfordview SAPS. At the time, I did not want to work at Vosloorus anymore due to various incidents that had taken place over time. I was a sergeant at the time. I worked from 2000 to 2004 at Bedfordview SAPS and was promoted to warrant officer during that time. I resigned in 2004. I joined the SAPS again in 2010 and started working as a detective at Germiston SAPS. I am familiar with all the accused in this matter, as we were all with the detective services for Vosloorus during 1988-1999. I was a sergeant and Richard Mdluli, a senior superintendent at the time. Nkosana Qimba held the rank of constable, and Mtunzi Omhlem Tembezi Mtunzi was either a sergeant or a warrant officer. Samuel Zamundao Dlomo was a sergeant at the time. I am, however, better acquainted with Qimba and Mdluli. I know Mdluli since 1986. At that stage, a few of my friends and I were playing together in a band, and we asked Mdluli to be our manager. During that same time, I was in a relationship with a girl from Vosloorus. I became aware that Mdluli began to visit my girlfriend behind my back. Mdluli knew at the time that she was my girlfriend. I wanted to continue to see her, but was advised by my friends not to continue with the relationship, as Mdluli does not take kindly to competition. I stopped seeing her. This event did, however, put a strain on my relationship with Mdluli. The band also stopped to exist shortly after that. I knew Qimba since 1994, and we started to work together since approximately 1997. As I started to get to know Qimba, I found out that he is very well acquainted with my mother-in-law and that he came there often. We got closer during that time due to working together. I also knew Tsidi Buthelezi, now deceased, from before 1990. I knew Buthelezi because I used to visit the house next door to where she stayed. At that time, she still was staying with her family. Buthelezi was attractive, and a lot of men wanted to get to know her better. She later went to stay at Windmill Park. I know this house belonged to Mdluli. Buthelezi told me that she had a relationship with someone. She never mentioned his name. After the murder of Alfred Ramokhibe alias Opa, deceased, I realized that it might have been the same person she was talking about. I was thus aware of the fact that someone had a relationship with Buthelezi and that Mdluli was against it. Buthelezi confided in me that she was very unhappy in her relationship with Mdluli. She had started a new relationship, and Mdluli did not want to accept the fact that Buthelezi did not want to see him anymore. I also knew that she had a child with Mdluli. These conversations with Buteles happened prior to the murder of the deceased. I was not aware of an attempt on the life of the deceased. I only learned about it after the deceased got murdered. I cannot remember the date, but I remember the day the deceased was murdered. I was in my office and on duty. Later that day, I think after lunch, I heard there was a shooting incident and that Dlomo was involved in the shooting. I shared the office with Sergeant Nomaan at the time. I do not know whether he was also in the office when the news came of the shooting incident. I went to the crime scene with some of my colleagues. When I got there, the deceased was already removed from the scene. I tried to assist in identifying witnesses to the event, but was not successful. I cannot remember whether Dlomo was still on the scene or not. In fact, people were gone already. We went back to the police station where I met Dlomo. He told me that he was attacked by 2 or 3 guys who were passing by whilst he was busy attending to the scene. He informed me that the deceased wanted to show him the crime scene where he was attacked previously. He also said that the attackers took his firearm. Shots were then fired and the deceased was killed. He said that the attackers had a firearm with them before they took his. The day after the incident, people started talking and it became known that the person that was killed the previous day had a relationship with Buteles. I already knew the previous day that Dlomo used Mdluli's green Volkswagen Golf to do the pointing out. I was surprised to hear that Dlomo was allowed to use Mdluli's car. I have been a pastor's assistant since 1998 and started practicing as a pastor since 2000 and 2001. In 2000, I was in jail with Qimba. We were accused of stealing a car and were both arrested for it. There was 3rd person also detained on this is dead, but he has died since. I cannot remember his name, but he was also a member of the SAPS. We were detained at Johannesburg prison for 5 months after bail was refused. During this, Qimba and I became close. Qimba told me that the reason why he is there is because he refused to submit a statement against me in this case. He started opening up to me and he told me if Mdluli does this to him, he will also do the same because he knew everything about him. Qimba then told me that Mdluli was involved in the killing of the deceased. He was referring to the incident where the deceased was shot and killed. Qimba told me that Mdluli hired 2 people to kill the deceased. They came from one of the 2 hostels in Fosterras. He gave me the nicknames of at the time, but cannot recall the names. I told him to wait until we get out and then he must go to the Scorpions to inform them as to what had happened. I do not know whether he did in fact go the Scorpions. After we were released, we kept in contact and he used to come to church with me. I heard a colleague of mine talking about this case last year. I told him that I know certain information regarding this case. Not long after that, Lieutenant Colonel Du Plessis approached me, informed me that my colleague informed him that I had certain information relating to this matter. I told him I knew, and then he referred me to Lieutenant General Libya. I had a meeting with Libya in which I informed him about my knowledge in this matter. I am also aware of the firearms that were taken from Mdluli's safe. I think this happened just prior to the murder of the deceased. As far as I can remember, various R5 rifles and handguns were stolen from Mdluli's safe. I was told that someone broke into Mdluli's office. This person allegedly came through a first-floor window which opened up into Mdluli's office. The window is directly above the entrance to the charge office. I understood the case was open, but I saw a case docket.
Thank you very much.
Yes.
So, we can accept. Apologies. Thank you very much, Mr. Chauke. We can accept that on the 2nd of November 2012, you had all these statements in front of you, the police docket, the the heads of argument of your prosecutorial team argued quite vociferously in favor of pressing forward with the murder charges. Is that correct?
You mean at the inquest?
At the inquest.
Yes.
And I'm assuming that at this point, with the inquest judgment and the heads of argument and the docket with all these statements inside, you now were at a stage where you could choose. You could choose to continue with the murder charges and the related charges, or you could continue with the full review.
Yes.
Because at this stage, we can accept that you had not filed an answering affidavit.
Yes.
And I'm assuming that you consulted with your prosecutorial team.
Yes.
And your prosecutors were very senior, is that not correct?
Yes.
You had Advocate Van Zyl, Advocate Barnard, and Advocate Kgaleka.
Galeka, yes.
Kgaleka.
Galeka. Yes.
Thank you. And they were all very senior members.
Yes.
In fact, Advocate Van Zyl is one of the few senior counsel.
Yes.
And they were satisfied that there was a prima facie case to continue with the murder charges.
Yes.
And Van Zyl was of the view that although there was a circumstantial evidence...
Advocate Van Zyl?
Sorry, Advocate Van Zyl. I do apologize, Madam Chair. Advocate Van Zyl and Advocate Van Zyl will be coming to the hearing, and I do apologize, Mr. Chauke, for not producing his witness statement timelessly, but you will have it very soon. But Advocate Van Zyl...
Beg your pardon. Is the statement of Advocate Van Zyl available?
It is 80% done, Madam Chair. We are in the process of finalizing it. It is where Advocate Chauke is today. We were hoping to have it done by this morning to give to Advocate Chauke.
Are you going to be in a position to cross-examine the witness about what Advocate Van Zyl is going to say?
Advocate, I think Mr. Chauke knows Advocate Van Zyl's position. It is in the various correspondence, which I intend to take the panel later.
You see, we were referred to the prosecution.
Indeed, he holds the same view as in the prosecutorial...
Yeah. Let me finish. We were referred to the representation, which is the prosecutor's memorandum in relation to Mr. Mdluli's representation. Is Advocate Van Zyl SC the one mentioned at RM 00884, the one that you are referring to, together with Advocate Kgaleka and Advocate Barnett?
That is correct, Madam Chair.
The conclusion they reached, which was read earlier, was that there is no merit in the representations and that the trial should proceed.
That is correct, Madam Chair.
Yes. Let me just find out from Advocate Chauke. My recollection was that Advocate Chauke was asked about this representations and this memorandum, and he's testified to the effect that he subsequently discussed this matter with the team insofar as his intention to refer the matter for inquest was concerned, and they agreed with you.
Madam Chair, just to give you timelines, this is...
Before that, let me just check if I'm correct.
Yes, before the inquest was held, when I directed that an inquest should be held.
And they shared your sentiments?
No, of course, they have always been saying that they think there's a strong case, and I disagreed with that. That's why I referred the matter to the inquest.
Yes, thank you.
Thank you, Madam Chair. Just to clarify, we are dealing with the period post-inquest, where we have the inquest judgment.
So you say you referred the matter for inquest because of the disagreement of views between the team and yourself?
No, the disagreement of views is one thing, but the decision that was supposed to be made, it was made by me as the DPP.
No, that I understand.
Yes.
I'm just following up on the answer that you have just given now.
Yes.
And I'm just checking as to whether I've recorded it correctly.
Yes, that their view was that there was a strong case. That is correct.
Yes, that's prior the inquest.
Yes.
Thank you.
I just want to get the sequence right in my mind. You withdrew the charges and referred the matter for inquest.
Yes.
And counsel refers to the post-inquest events.
Yes.
The issue in terms of the terms of reference relates to your action of withdrawing the charges before the matter was referred to inquest.
That's how I understand it as well.
Not any decision you took, if any, post the findings of the magistrate.
Yes, but counsel was saying her understanding is that post that inquest and the decision, the delay that I had to make a decision after the inquest, that is the delay that is being referred to.
The issue is about the delay.
Yes.
Yes, thank you. Proceed, counsel.
Thank you, Madam Chair. Would you like me to clarify further, which is why I took Advocate Chauke to the terms of reference?
Yes.
Because I was
No, you don't need to clarify. I do understand.
Thank you.
Yes.
So, Advocate Chauke, at this point in November 2012, you had a choice. You could continue with either the murder or the related charges, or you could put in the answering affidavit to the full review.
What do you mean putting the affidavit to the full review?
You could continue with the full litigation, which was still pending.
Yes, the litigation was still pending, but I don't understand when you say I should have put an affidavit there. What are you referring to?
So no, let me explain.
Yes.
At this point, you have the inquest report in front of you, yes. And you now know the findings of the magistrate.
Yes.
And with regard to the full litigation, took your decision on review. And the decision that they took on review was your withdrawal of the murder charges and your decision to refer it to inquest. Is
yes.
that true?
Yes.
So in November 2012, you have the outcome of the inquest, yes. And you can reinstate the murder and related charges.
Yes.
And continue with the trial.
Yes.
And then you would effectively get rid of the full review because
yes.
they wouldn't have any complaint.
Yes.
Or you could elect to either only proceed with the murder charges or only proceed with the related charges.
Yes,
Are we on the same page?
yes.
And at this point, as you have confirmed, your prosecutorial team was of the view that you should go ahead and proceed with the trial.
No, not that I'm aware of. At that time, I had to make a decision whether to proceed with the murder charges or to proceed with the other related charges. And I decided then to proceed with the other charges except murder and attempted murder.
Madam Chair, I've sort of kept waiting for the right moment to object. This point around whether this charge, 3.12, refers to the pre-inquest or the post-inquest, has been dealt with Advocate Batoi, who has told us that it refers to the pre-inquest period. But I see the line is just continuing on the assumption that everybody accepts that the charge is about the post-inquest period. The testimony of Advocate Batoi is that this is about the pre-inquest period.
That is why I ascertained with Advocate Chauke, because the pre-inquest event relate to his action of withdrawing the charges before referring the matter for inquest. And that's what we dealt with extensively with Advocate Batoi.
Indeed. And on several occasions, she confirmed that it was when, in fact, it was even before the cross-examination. It was when she was engaging with the panel. And in the cross-examination, I confirmed that we can pull all of the parts in the transcript. But we don't accept the premise of our learned friend that this is about the post-inquest. That's not the evidence before us.
Recollection was correct. And I'll probably have to go back and read Advocate Batoi's statement. No mention was made of this aspect of the delay post-inquest.
No, she never mentioned the delay. What she complained about was that the decision to refer the matter to an inquest, which is pre-inquest, weakened the case of the state. She never complained about the delay. She said, your decision to take it to an inquest has weakened the case of the state. And that is clear also from her witness statement.
Counsel, perhaps this is an appropriate moment to pause so that you can have a look at Advocate Batoi's statement and the transcript. I suggest so because you came into this matter quite late when Advocate Batoi had walked away and before she finished her evidence, at least under cross-examination.
Thank you, Madam.
You can then proceed tomorrow, bearing this in mind, because I'm also getting confused while we are focusing on the post-events after the inquest.
Madam Chair,
Maybe you can assist us when you refer to all these documents and guide us as to what you seek.
Madam Chair, I understood my role
To establish.
as the evidence leader was to, when you are writing the report and you are discussing the permutations of what this clause means, to present all the evidence before you. It might very well be that you accept Mr. Chauke's and Ms. Batoi's interpretation or evidence relating to this charge. In that event, the SCA has pronounced on it and it's found that Mr. Chauke's decision was not irrational. And subsequently, the subsequent decision was then the NDPP's decision to the nollie prosecute. And then it's cadet Castro because then that is a full and complete answer. I am simply dealing with a situation which if the panel then says, but what does this really mean? What could it possibly mean? And it might very well be that the panel is of the view that, well, we are not interested in the interim period. It only concerns the 2nd of February decision, and it only concerns the April 2014 decision. And in that event, the SCA judgment is a full and complete answer.
Yes, my suggestion to you is to read Advocate Batoyi's affidavit and read the transcript relating to her evidence insofar as this aspect is concerned, because it does not appear to me that what you are pursuing with the witness, and correct me if I'm wrong, is a matter that Advocate Batoyi dealt with. And remember, she's a key witness here, and we rely on that foundational statement by her as the one who initiated this inquiry. We will also look so that we can understand also your way, so that we can understand what you seek to pursue with the witness. I'm really lost. I'm getting lost. But as we adjourn tomorrow, you'll probably assist us much better, because all along we have been working on the premise that Advocate Chauke's alleged unlawful conduct was his withdrawal of the murder charges against Mr. General Mdluli. Is that your understanding?
It is my understanding, Madam Chair, but you will note from the timelines, and I do not wish to argue because I do wish to take your point, but just to clarify, in 2012, the charges were not reinstated.
Yes.
But I will take your guidance.
Yes, maybe let's look into that. Who was supposed to reinstate the charges?
I understand it would be Mr. Chauke. Because at that stage, we did not have a SCA judgment. In November 2012, we had an inquest report, Madam Chair, and the full litigation. The NPA had not put in the answering affidavit as yet. So in November 2012, what we had is we had a magistrate's report of the inquest, and we had a pending full litigation, which at that stage the record had been produced, and there was a supplementary founding affidavit. But the NPA's founding affidavit had not been filed in November 2012.
But if at that time there was a pending litigation, what could Mr. Chauke have done?
The pending litigation was precisely of relating to continue with the murder charges or the murder and attempted murder and related charges. So, in my understanding is that Mr. Chauke could have gotten rid of the litigation if he decided, based on his own understanding, to reinstate the charges against the accused.
To reinstitute the charges?
Indeed.
After which event?
After the inquest judgment.
But there was pending litigation at that time, immediately thereafter.
But the pending litigation regarded precisely that, the withdrawal of the charges. So by reinstating the charges, the pending litigation would naturally fall away because it seeks a review of the withdrawal of the charges.
But the complaint is about his withdrawal of the charges.
Because at
Correct.
at that stage, Mr. Chauke did not reinstate. So it continued to be withdrawn.
Yes, and then full litigated. What did the SCA say?
The SCA in 2014 said that his decision was not irrational.
And what is the order saying?
The order then said that the NDPP would take the decision.
Ms. Advocate Ngasana.
Indeed.
Yes, now, why should Advocate Chauke be held responsible for the decision that was taken by Advocate Ngasana?
I am not saying that, Madam Chair. I'm definitely not saying that. In fact, I specifically canvassed with Advocate Chauke that the SCA has exonerated his decision of the 2nd of February 2011? 2012, as well as the subsequent decision in 2014 of the NDPP. So we cannot have those two. This clause 3.2.1, it does not make sense to if you read it with regard to those two decisions, because the SCA has pronounced on them.
So the issue you are now pursuing relates to the delay, or what?
So the issue is the only possible interpretation of 3.1.2 is in 2012 when Mr. Chauke had the inquest judgment before him. He did not reinstate the charges.
Can I comment, Chair, in respect of that?
Give me a chance, please. Yes, please do.
I heard counsel that she's also referring to Van Zyl, and I gave evidence and indicated that in 2012, when I instructed them to proceed with the other related charges, Advocate Van Zyl is the one who advised me that there is this pending review proceedings, which I will have to await for because my decision might be found to be irrational. And on that advice, I did not insist that they should continue with the prosecution of the other related charges without the murder and the attempted murder charge. I believe that will settle what counsel is trying to look at.
Madam Chair, could I just finalize the objection? So I've made one objection on the basis that Advocate Batoy's evidence is clear and unequivocal that charge relates to the pre-inquest. But my learned friend, Mr. Ramokhala, also points me to another facet of this. The NPA actually the evidence leaders instructed by the NPA attempted to amend the charges in order to include the post-inquest period in clause 3.1.2.3 of their application for an amendment. That was dismissed. So they knew that the charge is about the pre-inquest. They applied to amend it. It was dismissed.
Referring to the application to amend the terms of reference,
Yes, Madam Chair.
in terms of which this panel made a recommendation to the President.
Yes, Madam Chair.
The President has not made any decision. We are still waiting.
We have a long wait ahead of us.
You remember, we can only recommend as a panel. We wrote a ruling and submitted it to the President through the Minister. We are awaiting the decision of the President. But we take note of the point that you are making, an attempt to amend the terms of reference. And I think, in fairness to counsel, Advocate Mayeta, she came quite late into the matter, even long after that application to amend the terms of reference. After Advocate Batoyi had testified, that's why I advised her to have a look at her statement and the transcript.
Yes.
The transcript will also assist in relation to what was contended by the evidence leaders and the NPA in relation to amending the terms of reference.
Yes, thank you.
So I do not think that we should make any ruling at this stage on that point. We will afford counsel to have a look and read. As you can see with the kind of questions we are posing to you, we are getting even more confused because the case that has been before us in accordance with the terms of reference seem to be now shifting, and it's confusing us even more. So perhaps, unless my sisters would like to ask you any question, perhaps we should adjourn now.
As you prepare and look at material in preparation for tomorrow's continued questioning, you should be mindful of the fact that according to information at the inquiry's disposal, there has just been one withdrawal that was made by Advocate Chauke. And that is the withdrawal of prior the inquest. I am not aware of any other withdrawal that took place. So there's just one withdrawal, but if you come across any, also please address that. Right, thank you.
Thank you. I am indebted to the panel's guidance. I will certainly read. It is only my third week.
We take cognizance of that. That's why we advise that you read the statement of Advocate Batoyi and the transcript, particularly in relation to the charge 3.1.2. She was asked questions extensively about that as to what failure to continue means. If you can read that, it might just assist you. And tomorrow you can give us a roadmap. I assume that you would have familiarized yourself with that evidence that is already before us of Advocate Batoyi, and you'll be in a position to assist us.
Thank you, Madam Chair. I am indebted.
Advocate Chauke, we will pause now and reconvene tomorrow morning at 9 o'clock.
Thank you, Chair.
You are still under oath?
I confirm that, Chair.
Thank you, Advocate Mayet. We will pause.
Thank you.
Adjourn now.